information item 5, Contempt Civil 68 of 2025.
Yes.
Last occasion, Your Lordship,
I directed the Deputy Commissioner Chhabra to be here.
Yeah. Is he here? Has he understood what is it?
My Lord, there are certain issues which have come up here, Your Lordship. Lordship sees Your Lordship's order. My Lord, subsequent to Your Lordship's order, this deals with payment for some compensation for some land acquisition, Your Lordship. A representation has been filed, Your Lordship. But all the persons who are entitled to get compensation, they are not there, Your Lordship.
Maybe not there.
My
Suppose a person files, he will not forge anybody's signature, no?
No, obviously not.
There is no point.
Absolutely not.
Suppose only two persons join to file a representation. Then under such circumstances, if the details of others are also there,
The full details are not there, Your Lordship.
full details are not there means?
As in, Your Lordship, we have gotten this Vanshavali which was timely implemented to possible.
Yes.
So, all the so,
Full details means their address is not there?
my lord, not that. But all these persons, they have given some details in the representation paragraph 8 onwards.
Yes.
They are there.
Yes.
But Your Lordship, we have marked out the persons who are before, who have filed the representation. They are the family of Kripal Thakur, Bhutiya Devi, Dilip Kumar, Baneshwar Kumar Thakur, Deepak Kumar Thakur. The other co-claimants, Your Lordship, or the co-sharers, they are not there before us, Your Lordship.
No, they are not before us, but their details are there in the representation or it is not there?
Some details are there, Your Lordship, that the names are there, that's all. That's the
Names? No, their address is also there.
No, Your
Because
Lordship.
address is not there, only
Page
name
20,
is there.
page 23.
You provide them the address then.
They would have asked, we would have provided, but
आपको पैसा लेना है ना?
yes,
तो ढंग से लेना है ना? सबकी
we-
आइडेंटिटी जांच करनी होगी ना?
we'll give the details. Please.
You have this family tree,
I've given them a
I'm having.
right?
Yes,
You
give
have
it.
this.
Yes.
You give the details of every
Yes,
person.
we'll give minutes. We'll give it.
Do you get this?
अलग जस्ट हम्बल तो जो स्ट्रक्चर्स के पेमेंट की बात हो रही है उसमें जो शिफ्टिंग चार्जेस की बात हो रही है उसमें जिनके नाम पे अवार्ड है उनके 7 बेटे थे उसमें से सिर्फ एक बेटे की वाइफ और उनके 3 बेटे दोनों स्ट्रक्चर्स का पेमेंट क्लेम करते
नहीं,
हैं
ऐसा नहीं देखिए. जो क्लेम आपको देना है ना, जो लीगली जिसको पेबल है उसी हिसाब से देना है. ठीक है, इनके कहने से आप किसी का शेयर, इसीलिए ना आखिर सबको क्यों सुनना है? सबको इसलिए सुनना है कि किसी का शेयर किसी और को चला जाएगा तो दैट विल क्रिएट अ लॉट ऑफ प्रॉब्लम, राइट? देन देयरफॉर जो भी ये आपको डिटेल प्रोवाइड करेंगे, किसी का सिग्नेचर फोर्ज करके तो आपके पास रिप्रेजेंटेशन नहीं फाइल कर सकते. तो फिर हम लोग का लीगल सिस्टम में मान लीजिए 4 भाई किसी केस में पार्टीशन सूट मान लीजिए, 2 भाई आते हैं 2 भाई नहीं आते हैं, तो उनको भी हम डिफेंडेंट बनाते हैं. ठीक है, जो लोग हमारे साथ हैं लेकिन हमारे पास वकालतनामा नहीं होता है तो उनको हम प्रोफॉर्मा डिफेंडेंट बनाते हैं. उनको नोटिस जाती है, उनका हम लोग पता करते हैं कि उनका क्या स्टैंड है, वेदर दे आर कंटेस्टिंग और दे आर डिफेंडिंग. अगर मान लीजिए ये सब लोग आ जाते हैं और आपका इक्विटेबल डिस्ट्रीब्यूशन के हिसाब से आपका जिसका शेयर है, आपको लगता है कि भाई इतना शेयर होना चाहिए. मान लीजिए आप किसी भी ब्रांच का आप 1/7 शेयर आप डिसाइड करें और वो आदमी आपके पास आता है और आपको सेटिस्फाइड हो जाते हैं आप कि भाई ये इस ब्रांच का है, इसका 1/7 शेयर होता है, तो बाकी जो लोग नहीं आ रहे हैं तो कम से कम उतना पोर्शन तो आप उसको देंगे ना, इतना ही है. और बाकी जिन लोगों का नहीं बनता है उसको आप अपने पास रखेंगे, वो कभी भी आ सकते हैं.
जो हियरिंग हो रहा था इनफैक्ट एनटीपीसी में जो इनको नोटिस दे रहा है सेम चीज दे आर सेइंग कि आप अपने जो सबका दे आर क्लेमिंग कि दोनों स्ट्रक्चर्स का हमको दे दें एनटीपीसी एक्ट
नहीं, ऐसा उनका तो मन करे तो आसमान ले लें आपसे, लेकिन उनका जितना एंटाइटलमेंट है आप उतना ही उनको देंगे. एंड जिसको जितना दे रहे हैं उसमें एक रीसेंट ऑर्डर पास कर दीजिए कि इस ब्रांच का इतना बनता है, इतना शेयर बनता है, हम इसको इस तरह से दे रहे हैं, तो हम लोगों को क्या दिक्कत है इसमें? लेकिन जिसको जितना बनता है उसके लिए उसको दौड़ना उचित नहीं है ना. बस दैट इज द ओनली थिंग. दिस इज द ओनली थिंग यू हैव टू. हाउ मच टाइम डू यू नीड टू प्रोवाइड दिस?
Next week we'll provide minutes.
Okay, I'll post it after 3 months. I'll post this after 3 months.
We'll
In the
provide it.
meantime, आप नहीं कोऑपरेट करेंगे, आपकी तरफ से कोई नॉन कोऑपरेशन नहीं आना चाहिए।
We will provide the entire details plus with
आप
address.
एक और काम करेंगे, इनको कोई अपना ईमेल एड्रेस दे देंगे, ठीक है? उनको कुछ भी कम्युनिकेट करना होगा, कोई भी रिक्वायरमेंट होगा, तो ना आपको ज़्यादा परेशान होने की ज़रूरत है, ना उनको ज़्यादा परेशान
We
होने
will
की
provide.
ज़रूरत है। वहाँ पे जाके भीड़ लगाने से क्या फ़ायदा है?
We'll
He
provide.
will provide a date also कि भाई सब लोग इस दिन आ जाइए, जो भी होगा, ठीक है? तो अकॉर्डिंगली जिनका ईमेल होगा अब उनको आ जाएगा, नहीं तो बाकी लोगों को पर्सनली होगा। एक चीज़ और है, जब भी आप कोई प्रोसीडिंग करें और नेक्स्ट डेट आप दें, डेट पर हाथ की हाथ डेट देंगे और सबसे साइन करा लेंगे, नहीं तो वो बोलेंगे हमें पता ही नहीं था, हमारे पीछे डेट दे दिया, ये सब अननेसेसरी प्रॉब्लम्स होते हैं, ठीक है? क्या नाम है आपका?
रमेश टोलर।
जरा वो अपीयरेंस देखिए, कंटेम्प्ट सिविल 68 of 2025. Mr. So-and-so, you are the Deputy Commissioner? The Deputy Commissioner of Chatra District is present in the court. He has furnished a copy of the genealogy of late Rohan Thakur, alias Rohan Hajam, son of Surjan Hajam, in whose name the award has been prepared. He has submitted that only some of them have approached him for the purposes of taking compensation, but rest of them have not approached, and therefore he is unable to pass an appropriate order. He has submitted that the details of the persons whose name has been mentioned in the representation, their necessary details are not available, and therefore he is unable to communicate and issue notice to those persons. The learned counsel for the petitioner has also been handed over a copy of the genealogy, and he submits that he shall provide the details of each and every person whose name is mentioned in the genealogy, so that appropriate share with respect to each and every person can be earmarked and be provided. हो जाएगा एक हफ्ता में, are you sure?
Yes, ma'am.
He submits that he shall need 1 week time to do the needful. The Deputy Commissioner who is present in the court pursuant to the last order has submitted that if the details are provided, there may not be any problem in doing the needful, but the allocation of compensation has to be done as per the share which is to be determined. आप अपने उसमें खुद से email वगैरह सब दे देंगे.
Yes, ma'am.
The learned counsel has also submitted for the petitioner at this submits that he shall also provide his email ID to the office of the Deputy Commissioner so that communication in connection with the proceedings is made without any gap. Pose this case on 23rd of June. It is expected that in the meantime, the grievance of the petitioner and his other family members will get redressed. The supplementary show cause be filed by 19th of June. If the supplementary show cause is filed, then the Deputy Commissioner need not remain present in the court on the next date.
For hearing item 7, second appeal 151 of 2022.
In this case, what happened? The suit was filed for declaring the sale deed in favor of the defendant as null and void, and if dispossessed during pendency of the then recovery of the possession. And the second relief was for declaring that the defendant cannot claim right title on the basis of the said sale deed. But the trial court has come to the finding that the sale deed is
Valid.
Appellate court, without discussing anything on the point or evidence on the point of sale deed, had shifted to on the point of adverse possession and given the finding that since they had not claimed for possession for last even 24 years, therefore the appellants are on the basis of adverse possession their title has been declared. There is no finding by the appellate court with regard to the sale deed executed.
Yes,
Yes.
that is a concurrent finding.
No finding.
No, there is a finding.
No finding. No finding. Yes.
Please don't.
Yes. No,
There is
that
a concurrent finding.
no finding on that point.
Just.
Yes. With regard to Schedule A property, there is no claim. Schedule A, they have said that जो उनके पास हुआ था वो उससे हमको कोई ये नहीं है. Schedule B जिसका defendant claim करते हैं, उस पर there is no finding. (7.10) page 12.
Just.
And not even discuss any evidence. He is the final court of fact. He has not discussed any evidence.
आप जरा पेज नंबर 12 में आइए appellate.
Yes. Page 12. 7.10.
7.10 के ऊपर.
Yeah.
Further, the document evidence of defendants superseded the oral evidence advanced by the plaintiff in all respect. Therefore, this court declares the sale deed of the plaintiff as valid document and also transactions done between the parties. मिला? है ना?
But without discussing any evidence.
कोई मतलब नहीं. आपने फाइल किया है क्या?
Milord?
You are the plaintiff. Correct?
Yes.
आपने तो नहीं फाइल किया है. ना ही इस पर कोई क्वेश्चन ऑफ लॉ बना.
नहीं क्वेश्चन ऑफ लॉ.
अब आपके एडवर्स पोजीशन की कहानी सुनो. 99 का सूट है.
Yes.
रिटन स्टेटमेंट में आ गया कि 2000 में जो है प्लेंटिफ का पोजीशन हो गया. करेक्ट?
As per them, they were
आप-
disposed. Yes.
अच्छा ठीक है. आपको ऐसे नहीं समझ आ रहा है.
नहीं.
आप देखिए 7.8.
Yes.
It is admitted by the defendants that they are not in possession of the suit property since 7/7/2000. ठीक है.
It is their case.
एक सेकेंड.
Yes.
उसके बाद पेज नंबर 12 में आए.
Yes.
Be that as it may so. ठीक है. As discussed earlier, the adverse possession of the plaintiff have already ripened against the defendants in the year 2012.
Yes.
1999 के सूट में adverse possession 2012 का डिक्लेयर होगा.
Milord,
बताइए. 1999 का सूट में ड्यूरिंग द पेंडेंसी जो पोजीशन में रहेगा उसका एडवर्स पोजीशन
the
डिक्लेयर हो जाएगा.
relief is the plaintiffs for declaring the sale deed as null
आप
and void.
एडवोकेट है ना.
Yes.
एडवोकेट की तरह से सुनो.
No, for declaring the sale deed as null void and for recovery if dispossessed. I was claiming that in 99 also it is in my possession.
We are not concerned with that.
It is in
हम
our.
सिर्फ ये देख रहे हैं क्या क्वेश्चन ऑफ लॉ बना है कि एडवर्स पोजीशन का कोई प्ली था कि नहीं था. एडवर्स पोजीशन का कोई प्ली नहीं था. एपेलेट कोर्ट ने एडवर्स पोजीशन इस ग्राउंड में दिया है कि ड्यूरिंग द पेंडेंसी ऑफ द सूट
Admitting, yes.
द प्लेंटिफ रिमेन. चलेगा.
Yes. Admitting that during plaintiff ये admitted that
हम
even
तो शॉक्ड हो गए. मतलब कल तो हम देखे ही नहीं थे ये देख.
admitting that even if it is accepted from 2000 then also it is 2012.
ऐसे इस तरह से एडवर्स पोजीशन
he has
होता
not discussed all
है. इस
anything.
तरह से एडवर्स पोजीशन होता है क्या? ड्यूरिंग द पेंडेंसी ऑफ द सूट जिसके पास प्रॉपर्टी रहेगा उसका एडवर्स पोजीशन डिक्लेयर हो जाएगा. यस.
Milord, but-
सूट में क्लेम करना पड़ेगा ना एडवर्स पोजीशन.
Suit plaintiff.
मिस्टर अरविंद कुमार यू जस्ट टेल अस.
Yes, plaintiff.
सूट में एडवर्स पोजीशन क्लेम करना ना होगा.
कंप्लेंट में थ्रू आउट प्लीडिंग है, इट इज इन आवर पोजीशन, इट इज
आपको
इन
बात नहीं समझ आ रही है ना, आप
Yes.
ऑर्डर पढ़िए, ऑर्डर
Yes.
अब आप सुप्रीम कोर्ट लेके जाइएगा, हम कुछ कर नहीं सकते। इतना बोलने के बाद भी नहीं समझ आ
नहीं,
रहा है तो हम
समझ में आ रहा है कि जहां पर फॉल्ट है वो तो हम अपने एडमिट कर रहे हैं कि विदाउट, बट देयर इज
concurrent finding है,
देयर इज
you are not aggrieved by that, that is not the question of law, हम उसके beyond नहीं जा सकते।
because the relief as claimed me para 13, may I read that only relief I am reading thereafter. That under the above facts and circumstances, plaintiff prays for following relief: a decree declaring that the sale deed bearing number 256 is bogus, inoperative, and as suit fit to be cancelled, and for confirmation of possession in the event of this dispossession pending the suit, then for recovery of possession. For permanent injunction restraining the defendant from claiming it herself as the owner of the suit property on the basis of the forged and fabricated sale. This is the relief.
कोई है डिक्लेरेशन कि मेरा एडवर्स पोजीशन डिक्लेयर कर दीजिए।
Not on adverse position, for confirmation of position का confirmation of position.
Second appeal number 151 of 2022. For the learned counsels appearing on behalf of the parties. This second appeal was admitted for final hearing. This second appeal has been filed against judgment dated 28/4/2022, decree signed on 9/5/2022, passed in civil appeal number 64 of 2018 by District Judge Roman 2 Devghar, by which the appeal has been allowed and the judgment and decree passed by the civil judge senior division Roman 4 Devghar entitled suit number 35 of 1999 dated 31/8/2018 has been set aside. This appeal was admitted for final hearing by the order dated 30/1/2025 on the following following substantial question of law. The records as received from the court concerned reveal that the suit was filed. इसका थोड़ा डिटेल प्लेंट का कल हम लिखा दिए, ऑलरेडी डिक्टेशन में टाइप भी मेरे पास करके आया हुआ है. Primarily the suit was filed seeking a declaration that the sale deed bearing number 256, which was admittedly of the year 1997, was bogus, inoperative, and was fit to be cancelled, and for confirmation of the possession of the plaintiff. And in the case of event of dispossession pending suit, then for recovery of possession. A prayer was also made seeking permanent injunction restraining the defendant from claiming herself to be the owner of the suit property. The sale deed was executed by the plaintiff.
Original plaintiff.
The sale deed was executed by the original plaintiff in favor of the sole defendant. Upon perusal of the entire plaint and also the relief, this court finds that there was no foundational pleading with regard to claim of adverse possession of the property. Rather, essentially, the suit was filed seeking declaration of the sale deed executed by the plaintiff in favor of the defendant as bogus, inoperative, and seeking a permanent injunction upon the defendant from claiming herself to be the owner of the suit property. at the time of filing of the suit in the year 1999, the plaintiff claimed to be in possession of the papers. The learned trial court framed. The defendant had filed a written statement stating that they were dispossessed from the property since 7/7/2000, and further stating that they were dispossessed of the property since 7/7/2000. The learned trial court framed as many as 9 issues, including issue number 4 and 5, dealing with the four, 5 and 7. इसको कोट ही कर देंगे issues, ठीक है? The issue number 4, 5, 6, 7 and 8 was decided by the learned trial court after taking into consideration the materials on record, and the learned trial court held that the plaintiff failed to prove that the sale deed dated 3/2/1997, sale deed bearing number 256 dated 3/2/1997, executed by the plaintiff Sudama Devi, was illegal, operative and without valuable consideration, and held that the plaintiff was not entitled for the relief as claimed by them. The learned court further recorded that the plaintiff failed to prove that the sale deed was managed by playing fraud, misrepresentation and undue influence upon Sudama Devi, and also failed to prove that possession of the suit property was not given to the defendant after execution of alleged sale deed. As such, the suit filed by the plaintiff against the defendant was not maintained. So far as the learned appellate court is concerned, this court finds that since there was no plea in connection with adverse possession in the plaint or in the written statement, there was no occasion for the learned trial court to frame an issue of adverse possession. However, the learned appellate court recorded that in the written statement, the defendant had stated that they were dispossessed from the property since 7/7/2000. The learned appellate court further recorded that in spite of the defendant having been dispossessed from the property since 7/7/2000, did not take any effort to recover the property from the plaintiff, and accordingly held that the adverse possession of the plaintiff adverse possession of the plaintiff against the defendant ripened in the year 2012. The learned court, prior to deciding the issue of adverse possession, also framed an additional issue, that is whether possession of plaintiff became adverse to the defendants despite the fact that the defendants have registered sale deed in their favor, and whether such adverse possession has made the defendants herein remediless to ousted the plaintiffs from the suit property. The appellate court, however, recorded a finding that from the documentary evidences of the defendant, superseded the oral evidence advanced on behalf of the plaintiffs in all respect, and the court declared that the sale deed of the plaintiff was a valid document, and also the transactions done between the parties. Thus, there is a concurrent finding with regard to the legality and validity of the sale deed executed by the original plaintiff in favor of the defendant. However, the learned appellate court framed an additional issue with regard to adverse possession of the plaintiff. This court finds that framing of such an issue was absolutely beyond the pleadings of the parties, and the appellate court had considered the plea of adverse possession, which according to that appellate court, it matured during the period from 7/7/2000 to the year 2012. This court finds that framing of such an issue at the appellate stage and recording a finding that the adverse possession matured during the pendency of the suit is ex facie perverse and is beyond the scope of the suit itself. If the adverse possession is to be decided, then the basic pleading has to be there in the plain/written statement, which was subject matter of consideration before the appellate stage. This court is of the view that possession of one or the other party during the pendency of the suit can never be a ground to declare adverse possession. In view of the aforesaid facts and circumstances, the first question of law is decided in favor of the appellant and against the respondents. And since the plea of adverse possession was never there at the stage of trial of the suit in the plain/written statement, and the finding of the learned appellate court is based on so-called adverse possession during the pendency of the suit, there is no need, and the first substantial question of law having been answered in favor of the appellant, there is no question of no question of taking any further evidence in that connection. Both the questions of law are accordingly answered in favor of the appellant. This appeal is accordingly allowed. The judgment passed by the learned trial court, the judgment passed by the learned trial court is hereby upheld. The appellate court's judgment is set aside. That's all. इसको हम लोग सिर्फ एडवर्स पोजीशन के पॉइंट पे सेट असाइड करेंगे ना,
Yes.
to the extent
point
it
of
relates to the
Finding
on the point of
Adverse.
adverse possession and the discussions in that connection. ठीक है, इसको थोड़ा सा हम इसको ऑपरेटिव क्वेश्चन थोड़ा ध्यान देंगे क्योंकि थोड़ा सा चेंज होगा. I'm just telling you. I will take care that the sale deed has been held to be valid by both the courts. Correct?
Orders to defect atom 1, second appeal 242 of 2023.
This IA has been filed for ignoring the defect issue.
You take out the fresh certified copy and file it.
Let's see what happened. That in the understanding of the first appellate court there, they were saying that since the matter has been disposed of, so only that defect can be cured by miscellaneous application, which we filed, and that has been incorporated.
So therefore, a fresh decree must have been prepared incorporating that.
No, they have in that order of miscellaneous civil application, that order has been incorporated, but not the in decree itself.
So they will do it. They are bound to do it.
Then this order may be observed. So that otherwise, again they will say that since that has been disposed, so the only recourse is that miscellaneous civil application has to be done.
लिखिए जरा ऐसे नंबर 242 of 2023 with IA number 6729 of 2024, IA numbers 9248 of 2024, and IA number 2484 of 2025. The learned counsel for the appellant has submitted that a defect was pointed out by the office that address of respondent number 2A to 2C was missing in the
Appellate court decree.
appellate court decree. He has submitted that interlocutory applications have been filed for ignoring the defect. However, at the same time, however, at the same time, an order dated 31/1/2025 has been annexed, along with the IA number 2484 of 2025, mentioning therein that a miscellaneous case number 1 of 2024 was filed, and the there is an order of rectification of the decree.
Page number 10.
Yes, the rectification of the decree is as under. पेज नंबर 10 में ना जो बोल्ड पोर्शन है उसको अंडरलाइन बोल्ड अंडरलाइन पोर्शन है उसको. The learned counsel submits that the learned counsel submits that as of now fresh decree has not been prepared. Considering the order passed in miscellaneous case number 1 of 2024 dated 31/1/2025, there can be no doubt that the necessary corrections are to be carried out in the decree also. The counsel for the appellant is directed to bring this order to the notice of the concerned court so that necessary corrections are carried out in the decree, and after necessary correction the appellant would take out a certified copy of the same and file it before this court. Need will be done by the appellant within a period of 4 weeks from today.
Sufficiently.
Within a period of 4 weeks from today. बाकी तो कुछ और आईए नहीं है.
नहीं.
All the IAs are closed.
अपीयरेंस दे दीजिए.
हाँ, एक तो डेट देंगे. 4 हफ्ता बाद का कोई एक तो डेट देंगे. 5वां हफ्ता. On 3rd of April under application.
Porter Saturn Q second
इसमें शायद ऑथेंटिकेशन फी भी लगता है 10 रुपए का डाल के फाइल करना.
Porter Saturn Q second equal 396 of the 2018.
Second appeal number 396 of 2018. Notices were issued upon respondent number 226. As per office note, respondent number 3 has expired. Respondent number 4 has been served through Sun, which is accepted as, and accordingly the service of notice upon respondent number 4 is accepted as valid. Respondent number 5 has been personally served. Respondent number 6 has been served through office clerk. Accordingly, the service of notice upon respondent number 6 is accepted as valid. स्टेट की तरफ से कौन है? Respondent number 1, the counsel for the respondent number 1 is appearing. However, service report upon respondent number 2 is awaited with respect to the ordinary process, and as per the registered cover, the notice upon respondent number 2 has returned on account of insufficient address. In view of the office note, the appellant is directed to take fresh steps for service of notice upon respondent number 2 at his present and correct address within a period of 2 weeks from today. Who is respondent number 2? West. Through speed post कर दीजिए. Insufficient address कैसे respondent number 2? Insufficient address. इतना clear address है, College Street. Through speed post and also registered through speed post and also through registered with AD. आप रिस्पॉन्ड नंबर 1 है? ये तो आपके रिलेटिव लग रहे हैं, है क्या? डिपेंडेंट डिपेंडेंट office to track speed post. Post this case on April 11th. Mr. S.K. Sharma is here. He was arguing this case on the last date. फिर ये ऑर्डर ही नहीं कंप्लाई होगा ना, आप हैं उनकी तरफ से, मिस्टर एस.के. शर्मा की तरफ से. ये केस में आप सूरज देव मुंडा कौन है? आप जानते हैं ना उनको?
He's for serial 3. He's for serial 3.
सूरज देव मुंडा को जानते हैं? Let a soft copy of this order be forwarded to the learned counsel for the appellant to ensure compliance.
Item 3, Contempt Bill 442 of 2022.
मिला?
You'll also the earlier order, you'll also the file a counter affidavit regarding the Kanya, and you'll also the Molvi the equivalent for the matriculation on intermediate. This affidavit is ready, you'll also
What is it? क्या है आपके affidavit में?
the affidavit is Kanya is equivalent to the matriculation and Molvi is equivalent to intermediate. Also NSL.
That serves your purpose.
Yes, Your Lordships. They have not given me Sardar certificate after giving representation also. And order
So
was,
they wanted what was the minimum qualification required?
minimum Your Lordship 12th, Your Lordships.
12. So
Yes, Your
according to
Lordship.
this affidavit, you are 12.
Yes, Your equivalent है Your Lordship. They are.
Where is Union of India?
Yes, Your
Now you have received this
Your Lordship,
affidavit.
right now, he has given me the copy just now, Your Lordship. Will you communicate this to
You
the...
communicate
Yes,
and
Your
do the needful immediately.
Yes.
You can't keep it hanging for indefinite.
Your Lordship, we had written several letters to the state.
Now you have got it.
Yes, Your
You,
Lordship.
this communication is sufficient.
Yes, Your Lordship.
Okay. लिखिए.
The regulation is also necessary, page number 10.
Contempt civil case number 442 of 2022. Counsel for the parties are present. A show cause has been filed on behalf of the Secretary, School, Education and Literacy Department, Government of Jharkhand, stating that
In contempt, you will also there is no party here.
कोई बात नहीं, सब ऊपर है. Stating that Fokania certificate is equivalent to the secondary examination board matriculation certificate according to resolution number 1792 dated 20/12/1977. Similarly, a Molvi certificate is equivalent to I.A. Correct? Para 10 of the affidavit is quoted as under. 9 and 10 दोनों quote कर. At this, the learned counsel appearing on behalf of opposite party number 2
Your Lordship.
has submitted that this show cause will be communicated to the opposite party number 2 so that appropriate order is passed and the grievance of the petitioner stands released. Considering the submissions, the matter is adjourned and is directed to be posted on 21st of March. Supplementary show cause complying the order of this court be filed by 17th. इसमें supplementary affidavit. हाँ, the show cause is taken on record.
Appearance. For admission item 4 contempt civil 647 of 2024.
Also, the last direction, we could not file any show.
There is a direction to file supplementary support to comply the order in letter and spirit.
इसमें क्या show cause आपको file करना है? क्या करना है?
हम ही नहीं बोल पा रहे हैं, कैसे बोले, हम ही जस्टिफाई नहीं कर पा रहे हैं मिस्टेक. हमारे पार्ट से ये हुआ है कि फॉलो अप नहीं, चिट्ठी गई है. फॉलो अप अगर होता तो एक एप्लीकेशन कम से कम रिकॉर्ड पे होना चाहिए था जो हम ही जस्टिफाई नहीं किए.
कौन है?
नहीं, ये वो तो जाएगा ही, सेक्रेटरी वाटर रिसोर्स है. और ये हम आप जो मेरे पास इंस्ट्रक्शन है अभी वो यही है कि चूंकि ये जो इनको एडमिसिबिलिटी है वो हेल्थ डिपार्टमेंट के ओपिनियन के लाइट में ही रिजेक्ट हुई थी. सर्कुलर अल्टीमेटली हेल्थ डिपार्टमेंट का है. दे आर अगेन इन कन्वर्सेशन विद हेल्थ डिपार्टमेंट की क्या इनका
See,
admissibility.
during the writ proceedings, the fact that he had undertaken that surgery is not indisputed.
हम बिल्कुल वो नहीं कर रहे. हम अभी
आप
आज
क्या चाहते हैं हमसे ये बताइए.
आज हम सिंसियर अपोलॉजी के साथ यही कहेंगे कि इसको अगर नेक्स्ट वीक या अगर कंप्लायंस के लिए हम क्या तो 2 वीक का समय दे दिया जाए तो हम इसको
Contempt case civil number 647 of 2024. Counsel for the parties are present. The learned counsel representing the opposite parties has submitted that one more opportunity be given to comply the order of this court. He undertakes to file compliance report within the period of 2 weeks. Like this, considering the prayer made, the matter is adjourned and is directed to be posted on 21st of March in the supplementary cause list. The compliance report be filed latest by 18th of March, failing which the opposite party number 1, the alleged the opposite party number 1 will be called upon to show cause as to why contempt proceedings be not initiated against him for willful and deliberate non-compliance of orders passed by this court, and appropriate proceedings be drawn for the same purpose. 18 मतलब 18, ये नहीं कि आप 21 तारीख को लेके आए. Let a copy of this order be communicated by the office to the opposite party number 1 to ensure compliance. आप भी कर दीजिए, यहाँ से भी चला जाएगा.
नहीं, हम बिल्कुल ये थे, फॉलो अप नहीं किया, ये हमारी गलती है. हम उस पार्ट से हमको लगता है कि हमको करना चाहिए था.
आप एक
वो होता तो एक
जस्ट
एप्लीकेशन
जस्ट एडवोकेट एक चिट्ठी दे दे, उसका काम नहीं है फॉलो अप करना.
एक हाँ वो
तो इसीलिए ये बोलिए ही मत कि आपकी गलती है. चिट्ठी चली गई, काफी है.
ये जो प्रैक्टिस में है वो हम करते
गलत है ना प्रैक्टिस. आप लोग फॉलो अप करते हैं, इसीलिए उन लोग की आदत हो गई है कि फॉलो अप करते रहिए. फॉलो अप का क्या काम है इसमें? एक चिट्ठी काफी नहीं है आपकी? कलम में ताकत नहीं है आपके? एडवोकेट के कलम में जज से ज्यादा ताकत होती है. नहीं
उतनी नहीं.
चलो.
Item 6, Contempt Civil 321 of 2025.
रिमाइंडर्स की जहाँ जरूरत पड़े तो समझ लीजिए आप किसी काम के नहीं.
Leadership, order passed by the Honorable Court is from page number 9 to 11, Your Leadership. Operative part is in page number 10, paragraph number 7 to 10. Page number 10, paragraph number 7 to 10, Your Leadership. It was
आप
regarding
क्या कर रहे हो? क्या चल रहा है?
Should we talk to the DLA? He said it's in process. Time limit given to try that.
प्रोसेस से ऑर्डर कब का है?
25/11/24, Your Leadership.
क्या प्रोसेस कर रहे हैं आप?
NOC.
किसका वेट कर रहे हैं? किसका वेट कर रहे हैं? ये ऑफिसर कहाँ पर है? रांची में होंगे ना?
रांची.
उनको बोलिए ऑनलाइन ज्वाइन करें 2:15 बजे. नहीं 2:15
So,
बजे.
12
12 बजे. ऑनलाइन तो तुरंत ज्वाइन कर लेंगे, क्या दिक्कत है उनको? जरा उन्हीं से समझते हैं कौन सा प्रोसेस चल रहा है. करेक्ट? यस. कैन यू ज्वाइन ऑनलाइन? ज्वाइन कराइए ऑनलाइन. कोर्ट में नहीं बुला रहे, ऑनलाइन अपने चेम्बर से अपने सीट पे बैठ के ऑनलाइन ज्वाइन करें और हमें बताएं कि क्या चल रहा है. 48 लाख रुपए का मामला है. एवरी डे इज इम्पोर्टेंट ना. हर दिन का इंटरेस्ट कितना हो रहा है बताइए? हर दिन इंटरेस्ट चढ़ है ना, इसलिए ज्वाइन करें.
From date list for final disposal item 1, WPS 2907 of 2014.
For password in this case, Mr. Bhanu Kumar is to argue this case. Please on legs.
स्टेट का लास्ट टाइम स्टेट थे आप एक.
Yes.
ठीक है पास.
1 o'clock.
Sir?
If I may, 1 o'clock for password for 1 o'clock.
ऐसे टाइम नहीं हो पाएगा. आने दीजिए, स्टेट को भी खबर करिए. लास्ट टाइम जो काउंसिल अपील में थे उनको.
Item 2, first appeal 181 of 2022.
12:30 बजे आ सकते 12:30 Where is the appellant? Last time भी नहीं आए थे।
He has not appeared.
ये नीलेंदु कुमार की बुलाई, अनंत कुमार सिंह पहचानते हैं? रिकॉर्ड आ गया उसमें? क्या सूट था?
Not declaration of seeking declaration CLT number such and such or declare none and void about it. इनके कहना है कि ऑन दे किडनैप करके इनको हम लेके और रजिस्ट्री करवा लिए. He has appeared before the registrar 3 occasions or before registrar 3 occasions and sale deed has been executed. And thereafter he has filed a criminal case against me कि हमने इनको किडनैप करके ले गए और वहाँ इनसे जबरदस्ती साइन करवा लिया.
क्यों क्रिमिनल केस का तो कहानी नहीं पता। इनका कहना ये है कि इनको कंसिडरेशन नहीं है।
लॉट से कंसिडरेशन आया हुआ है.
पार्टली कैश है, 15 लाख का कंसिडरेशन है थ्रू चेक और आरटीजीएस, बाकी कैश का कब दिया?
एग्रीमेंट में ही है कि हम ये एग्रीमेंट एग्जीक्यूट हुआ है उसमें है.
क्या करते हैं आप? इतना कैश देते हैं?
उस समय फाइनेंस कंपनी में एक मैग्मा फाइनेंस कंपनी थी रामगढ़ में, उसमें काम कर रहे थे.
नहीं, वो तो आपने चेक का कहानी से बताया कि आप उन्होंने आपको फाइनेंस कर दिया, ठीक है? और बाकी
क्या रखा हुआ था.
वही जानना चाहते हैं क्योंकि आपसे पूछा गया है कि आप क्या करते हैं?
उस समय तो लॉट से वही कंपनी में काम करते थे. हिज प्रेजेंट टुडे
ये वही जानना चाहते हैं, इतना कैश आपके पास रहता है तो क्या करते हैं आप? What are you engaged? क्योंकि उनका ये भी कहना है कि कंसिडरेशन अमाउंट हमको नहीं है. आपके सेल डीड में चेक्स के बारे में लिखा है, चेक्स का कैसा पेमेंट किया है? कुछ तो आरटीजीएस दिख रहा है, एग्जिबिट सी दिखाइए. निकालिए एग्जिबिट सी. सेल डीड कब का है?
ये
2012 का है ना सेल डीड?
2013 का 88 2013 12
साइंस तो सब 2012 का है.
लॉट से इसीलिए तो पहले सारा पैसा ले लिया, सारा कुछ साइन हो गया और 2 बार गए तो लिंक फेल था, तो नहीं हो पाया. तो फाइनली जो हुआ 12/1/2013 को
रजिस्ट्री उस दिन हुआ, लेकिन 2012 को साइन सब 2012 को हुआ है एडमिटेडली वेंडर का. ये जब रजिस्ट्री हुआ तो ही मस्ट हैव गॉन देयर, है ना? फिजिकली प्रेजेंट रहे होंगे ना, उसके बिना तो नहीं होगा. अच्छा, तो वहाँ पे फिजिकल प्रेजेंस में तो वो सब होता है ना, फोटोग्राफी और
सारा कुछ होता है लगा हुआ है. तो ये भी आया है कि वो इंक्लूडिंग इन्वेस्टिगेशन क्रिमिनल केस में उनको कोई फोर्स नहीं किया, उनको बार-बार पूछा गया कि कोई ही नहीं है, उन्होंने बोला कि हम अपनी मर्जी से कर रहे हैं. सारा कुछ है क्रिमिनल केस में आया लोग.
एक्यूटल हो गया?
नहीं, वो चल रहा है, वो हाई कोर्ट से स्टे है.
हाई कोर्ट से स्टे
फाइल सीआरएमपी एप्लीकेशन की कॉग्निजेंस ऑफ दैट हैज बीन स्टे बाय द.
अब आप हमको ये बताइए कि आपको चेक नंबर जो है आपने सैलरी में लिखा हुआ है ना, चार चेक, करेक्ट? बताइए, 4 चेक है ना? आपका एग्जिबिट सी है चारों चेक का, बताइए। पहला चेक नंबर 348054, 6,50,000 का, कौन सा एग्जिबिट? कब का है, कब एनकैश हुआ है? डेट बताइए, एग्जिबिट सी से मैच करा।
16/1/2013।
16/1/2013, ये तो दूसरा चेक है, 48792, 48792, 6,50,000 का 2 चेक है, ये दूसरा चेक का कहानी है, ठीक है?
17/10/12
कहाँ है? इस डीड में चेक का डेट नहीं है, लेकिन आपने इसको एग्जिबिट किया है कि ये चेक सब इनकैश हो, दिखाइए।
एक 2013 से 16/1/2013,
वही तो।
16 जनवरी अमूज कुमार 48, चेक नंबर है 48792, 6,50,000।
वही तो, एक ही दिख रहा है ना, आप अपने डीड में देखिए, 4 चेक है, दिखाइए। और प्लेंटिफ का क्या नाम है?
कुमार अमूज कुमार विश्वास।
अमूज कुमार विश्वास, बताइए।
इसको वेरीफाई करें।
वही ना, वही वेरीफाई करने की ज़रूरत है, हम कोशिश किए, हम नहीं कर पाए। आपको जो इतना बात बोल रहे हैं, तो कोशिश तो आप कहीं किए होंगे, तभी बोल रहे हैं आपको। नहीं है ना? पूछ लीजिए, अपना आपका क्लाइंट है, पूछ लीजिए। प्लेंटिफ नहीं अपीयर होगा, अपीलेंट आप बाहर जाके पूछिए, यहाँ पे नहीं पूछिए, ठीक नहीं लगता है ना, इट इज़ नॉट प्रॉपर आंसर। प्लेंटिफ अगर यहाँ पे अपीलेंट नहीं अपीयर होगा तो पुलिस स्टेशन से नोटिस करेंगे, ऐसे केस क्लोज नहीं कर सकते, क्योंकि काफ़ी सीरियस एलिगेशन, लेकिन आप उनसे समझ के हमको बताएं। आइए 5-7 मिनट में, ठीक है? आप
supplementary serial 6, the DLO is present in the court. If he can be present.
He's present in the court.
No, he is here.
आपने बुला लीजिए, कहाँ है, बुलाइए, अभी बुला।
Pass.
Orders notified item 3, CMP 580 of 2023.
So I create 2 weeks time for removing all defects. There are 9 defects lost.
रेस्टोरेशन में 9 डिफेक्ट, ऐसा नहीं हो कि रेस्टोरेशन का रेस्टोरेशन फाइल करना पड़े।
नहीं
हाँ? CMP number 580 of 2023. Counsel for the appellant prays for and is granted time till 21st March to remove the surviving defects preemptively. If the defects are removed within time, post this case under appropriate heading on 28th of March.
Item 4, CMP 794 of 2023.
Same order. Defective है?
Yeah.
कोर्ट में या नहीं बोला जाता है. That is not the appropriate language for the court. Yes.
Item 5, CMP 799 of 2023.
That is a restoration petition, but there is 4 to 9 is a defect and 15 is
Same order, you remove the defects.
We remove the defect. Number 4 defect. Name of the petition number 5 that should be corrected before by the court below. And in this case, can you see the page 21 by the input order that was the several. It was remanded to the court below for so far defect number 21 to 29, page 21.
Yes.
That 21 to 29 it was remanded, but till now, now there is some defect that has been communicated by the letter dated 8/2/2021. The defect number 21 not removed. In the code below, it was sent for remove the defect, that is page 21 mentioned, and the letter has been sent by the code below on code below by which it has been informed that defect number 21 not removed and 42 to 44 has not been removed. And name of the respondent number 5 is not mentioned. The letter, can you see that?
Which letter?
That is the last letter. It has been. It
Page
was
number?
sent by the Registrar General to the
Page
person.
number?
Page. Uh, 19/12/2020 sent for correction and 8/2/2021 sent after correction. That is the letter 8/2/2021. It has been pointed out defect number 21 not removed. Respondent number 5 which is in the serial number.
कहाँ लिखा है इस document में defect number 21 is not mentioned. Where is it mentioned?
Yes. Can you see the page 21?
24.
No, 21 of the input order for which I have filed the.
But that I have seen 21 to 29.
21 to 29.
Yes.
And the defect and the letter which has been sent by the court below 8/2/2021, 21 after correction which has been sent. Kindly see the defect number 21 not removed.
कहाँ लिखा है defect number 21 not removed?
दिखा है. Defect number 21 not removed. Respondent number 5 not mentioned. Name not mentioned. 22-23 removed. 42-44 has not been removed. Last letter देखिए ना. 8/2/2021 by the court below. एकदम last page में है. Last page.
Your case has been dismissed on account of non-removal of which defects?
That is the non-removal of the defect from 1 to 20. 20 and 2064.
Madam, if you want any defect to be ignored,
Yes.
you have to file an interlocutory application.
No, in this case, I take 4 weeks time may be granted to file the to remove the defect. I shall remove the defect, all defect except 4. Name of the petition number 5. That is not mentioned in the code below also. In this case, is the defect number 4 to the
देखिए, the learned counsel for the appellant prays for and is granted time till 21st of March 2021 either to remove the surviving defects or to file appropriate application seeking ignoring one or the other defect. If this order is complied within time, preemptory post this case on 28th of March. दो काम कर दीजिए, या तो रिमूव कर दीजिए या आईए
हम
फाइल
रिमूव फाइल करेंगे except one
उसके लिए आईए फाइल करना पड़ेगा।
except one because there is
यू हैव टू obviously नहीं ऐसे नहीं, आईए फाइल करिएगा, आईए में हम ऑर्डर करके इग्नोर करेंगे।
there is already an order to remove the defect. They have pointed out it is not
That's
there.
right, madam. You file your IE explaining everything.
Item 6 CMP 886 of
Audits are
2023.
filed instead.
I have given time till 21st of March. Is that sufficient?
Audits.
अच्छा, 28th of March कर दीजिए.
Yes.
If the defects are removed within the time, or if this order is complied, post on 4th of March. 4th of
Yes.
April.
If
Item
it is not
6.
possible, I shall file the IE. That is all.
Yes. If any defect you are not able to remove for whatever reason,
Yes.
you file an IE for
Yes.
ignoring the defect.
That
Then
should-
this order will. I have already stated.
Yes, that should be.
It is two part. One
Yes.
is either you remove the defects or you file an interlocutory application.
Yes.
In connection with one order.
Yes. I shall remove all the defect except one.
Yes.
It is not.
Item 6 CMP 886 of 2023.
ये डिफेक्टिव है। देखिए, CMP number 886 of 2023. Nobody appears. Time till 21st March is granted to the petitioner to remove the surviving defects preemptively. If the defects are removed within time, post on 28 and 6.
Item 6 call. Item 7 first appeal 62 of 2024.
has been filed, IE number 1165 of 25 has been filed for ignoring of the defect. Earlier also similar order was there, matter was there, where the common common award by the
In which record have you filed the
FA 55 of 2022.
FA
55
55 of
2022.
2024? The certified copy is there in that letter.
Yes, yes.
You have to file it, photocopy with authentication. Correct? I number 1165 of 2025. Counsel for the applicant has submitted that this interlocutory application has been filed for ignoring the defect. Regarding filing of certified copy. She submits that the certified copy has been filed in FA number 55 of 2024. And this case may be tagged with FA 55 of 2024 and defect regarding filing of certified copy will be. Considering the aforesaid submission, the defect regarding filing of certified copy of the impugned award
Yes.
award is ignored for the present, subject to filing of authentication fee in connection with the photocopy of the impugned judgment annexed with the memo copy. Since the certified copy is not being filed in the present case, the calculation of limitation be done from the date of pronouncement of judgment, improved judgment, that is 25/7/2019. Office to carry out further stamp reporting. आपका वो वाला मैटर कब आ रहा है?
कंफर्म
इसका डेट बताइए, केस नंबर बताइए।
हाँ कंफर्म
FA 55 और 24 का डेट
The next hearing date is on 8 April.
सभी जी FA 55 और 24 का डेट बताइए। FA 55 of 24 is scheduled to be listed on 8th of April. Office is directed to place this case with further stamp reporting on next Wednesday. Wednesday को आ जाएगा fresh stamp reporting के बाद।
जी सिमिलर ऑर्डर जो पास हुआ था दैट वाज ऑन in FA 57 of 2024 and analogous matter.
That's right. But same order we are passing.
Yes, yes.
Now the point is that in the next week it will again come up with fresh stamp reporting.
Yes.
They will point out everything so that you can remove the surviving defects prior to the next date.
Late.
Item 8, first appeal 153 of 2024.
Yes.
Lordship, two defects are surviving in this case, Lordship. One is relating to filing of limitation petition, IA for condemnation of delay, and second is that respondent number 11, 12 and 13.
FA number 153 of 2024. That till 21st March is granted to the applicant either to remove the surviving defects or to file appropriate petition in connection with one or the other defect. If this order is complied, post on 28th of March. Okay.
Item 9, CNP 154 of 2024.
Yes.
Pointed out that respondent was waiting nearly from last night and working late party. And mention in paragraph 8 of the CMP application that I filed the substitution application in second appeal and IA number is 8456 of 123. I have already filed the substitution petition in the second appeal, madam. So I have not made the
So those persons who are sought to be substituted in the second appeal are party here. CMP में उनको पार्टी बनाए नहीं हुआ है ना, तो भी तो उनको तो पार्टी बनाएंगे ना, उनको पार्टी बना दीजिए। जो भी आपने सब्स्टिट्यूशन में जिनको भी आपने पार्टी बनाने की प्रेयर किया है उनको यहाँ यहाँ पर भी ना आपको वो करना पड़ेगा, फाइल कर दीजिए उसको। CMP number 154 of 2024. The learned counsel for the appellant has submitted that as per office defect, the respondent number 14 of SA number 151 of 2019 has not been made party. He submits that one interlocutory application being IA number 8456 of 2023 has been filed in SA number 151 of 2019 as respondent number 14 died on 6/3/2023 and the said interlocutory application is pending. He submits that he shall file appropriate petition before this court so that the proposed legal heirs and successors of respondent number 14 of SA number 151 of 2019 are also made party in the present CMP. He prays for time. Let this matter be posted on 28th of March. The necessary affidavit / petition, the necessary petition be filed by 21st of March.
Password case, item 2, first appeal 181 of 2023.
पता चला?
चेक नंबर योर 34854 16/1/2013 का है क्या है चारों चेक का है
चारों चेक उसी दिन का?
ने 16/1 का है 16/1/2013 का है चेक नंबर 34 पहला लॉटशिप चेक जो है 16 जनवरी का है 48792 6,50,000
नहीं आपने जो स्टेटमेंट एग्जिबिट सी में लगाया है
लॉटशिप उसी में है लॉटशिप उसी में एक पहला 16 जनवरी 48792 6,50,000
48792
6,50,000 कैश हुआ
इसमें से जरा मार्क करके चारों चेक बताइए पेंसिल चेक नंबर टैली करना चाहिए ना? 348054 एग्जिबिट सी
एग्जिबिट सी है एक पेज मिसिंग 3 चेक का तो है इसमें
कौन से चेक का है बताइए नंबर उसमें से पढ़ के बताइए कौन से चेक का चेक नंबर बताइए स्टेटमेंट में चेक नंबर दिखना चाहिए ना बताइए कौन सा चेक नंबर दिख रहा है 48792 दिख रहा है एक हम 6,50,000 और बाकी
64805 1,91,000 का
उसमें चेक नंबर दिया हुआ है
लॉटशिप चेक नंबर मार्क
64805
1,91,100
ये चेक नंबर जो है 64805 इसमें आपको दिखाइएगा हमको तो इसमें नहीं दिख रहा कैसे बोल रहे हैं दिखाइए मार्क करके दिखाइए हमको हाईलाइटर दीजिए 64805 चेक नंबर दिखाइए Exhibit C by 1. अच्छा ये एक्सिस बैंक का है और 338879
1,00,000 है 15/1/2013
1 और HDFC बैंक
HDFC का है 348054
हाँ
16/1/2013 का 6,50,000
HDFC बैंक का एग्जिबिट कौन सा है?
उसमें तो नहीं
ये जो लिस्ट ऑफ एग्जिबिट्स है इसमें HDFC बैंक का लिखित जिक्र है क्या? HDFC बैंक का तो आपका
इसमें तो नहीं
शायद कोई एग्जिबिट नहीं है।
HDFC वाला but इसमें तो नहीं ये 18/1/2013 एग्जीक्यूट में नहीं
This has not been exhibited.
एग्जीक्यूट में नहीं HDFC बैंक में
बाकी तीनों का आपका क्रेडिट लिखा है।
इसका है लेकिन एग्जीक्यूट में नहीं HDFC
जब कोई डिनाई करे पेमेंट तो प्रूव कौन करेगा? कोई और डॉक्यूमेंट होगा? इसका कोई चेक बाउंस का केस तो नहीं चल रहा है?
नहीं
कभी हो सकता है, कभी
नहीं।
किसी भी कारण से बाउंस हो सकता है, ऐसा थोड़ी है।
चेक
इंटेंशन से और कैश पेमेंट का क्या प्रूफ है? Is there any proof regarding cash payment? $10,60,000 कैश।
एग्रीमेंट में ही है लॉस एग्रीमेंट में चुके है उसने एग्रीमेंट में ये है कि 7/1/2012 को 5 लाख रुपया फिर 5 लाख रुपया 30/4/2012 को फिर 60,000 टोटल 10,60,000 रुपया एग्रीमेंट में ये
एग्रीमेंट एग्जिबिट कराए हैं। एग्रीमेंट एग्जिबिट कौन सा है? एग्रीमेंट कौन सा एग्जिबिट है? एग्रीमेंट एग्जिबिट नंबर आपने एग्जिबिट कराया होगा एग्रीमेंट तो रेंट रिसीट, दाखिल खारिज, बैंक स्टेटमेंट एंड सेल डीड. आपने एग्रीमेंट को एग्जिबिट नहीं कराया. ये देखिए तो ये किसका रिकॉर्ड यहाँ छूट गया है. सिविल अपील केस नंबर सेकेंड अपील 151 ऑफ 22. The agreement of sale was executed by the plaintiff and said son-in-law Gurfan Ahmed on 18/6/2012. कहाँ है वो agreement? इसको आपने exhibit नहीं किया. Yes. एक चेक का कुछ अता पता नहीं चल रहा है. प्राइम फेस आपका एग्रीमेंट का कुछ पता नहीं और आपने अपने रिटन स्टेटमेंट में स्पेसिफिकली लिया है कि आपने एक एग्रीमेंट ऑफ सेल हुआ था आफ्टर पेमेंट ऑफ ₹10 lakhs अमाउंट. कहाँ है और क्यों नहीं प्रोड्यूस किया? Nobody appears. अब कहाँ है भाई इनके वकील साहब? Where is he? नीलेंद्र कुमार, अनंत कुमार सिंह. देखिए केस नंबर FA 181 of 2023. Nobody appears on behalf of the appellants in spite of repeated calls. On the last occasion also nobody had appeared on behalf of the appellants when the case was taken up on 19th of February 2025. The learned counsel for the respondent is present. And in absence of the appellant, certain queries has been made from the counsel for the respondent. It appears from the records that as per the sale deed, 4 checks were issued by the respondent which has been mentioned, whose details have been mentioned in page 6 of the sale deed. One of the check amounting to check number. One of the check is amounting to ₹6,50,000 of HDFC Bank Ramgarh branch. during check number 348054. However, from the records, the bank statement of HDFC Bank could not be figured out. It also appears that in the written statement, the defendant had taken a plea that there was an agreement of sale executed after giving an amount of rupees 10,60,000. 10,60,000. However, the same agreement also does not appear to have been exhibited. The learned counsel for the respondent has submitted that he shall carefully go through the records and clarify these aspects of the matter. The payment arising out of the same deed assumes relevance in view of the fact that it was a case of the plaintiff that he did not receive the consideration amount and he was forced to, and the sale deed was executed by playing fraud. यही allegation है? Since the fraud after kidnapping him aside, considering the fact that the appellant is not appearing, office is directed to issue notice to the appellant to the concerned police station. The service of the officer in charge of the concerned police station shall ensure service of notice in presence of witnesses, and after serving the notice shall, and at the time of serving notice shall also ensure that Aadhaar card, that the attested duly self-attested copy of the Aadhaar card of both the appellants are also taken. The details of the witnesses should also be mentioned in the service report. Post this case on 28th of March.
मार्च के बाद आएगा, ईद रहेगा, रमजान
खाली सर्विस रिपोर्ट आएगा, कोई बात नहीं, खाली सर्विस रिपोर्ट आएगा, ईद रहेगा, हम आपको टाइम देंगे, कोई ऐसा हम लोग को क्या हड़बड़ी है केस डिसाइड करने,
एक दो दिन के बाद,
लेकिन ये डीएफडी करके ना अपना बर्डन नहीं बढ़ाना चाहता। अब ये नहीं आ रहा है, एलिगेशन इतना सीरियस है, क्यों नहीं आ रहा है, काउंसिल भी नहीं आ रहे हैं, तो चीज़ें बहुत क्लियर नहीं होती। अगला आदमी आके बोल दे कि हमको नहीं कंटेस्ट करना है तो कोई बात नहीं है ना, लेकिन इस तरह से डीएफडी करना, फिर वो एक तो नया कहानी शुरू कर दे, इससे कोई फ़ायदा नहीं। और ये सब भी आप थोड़ा देख लें, क्योंकि जब कंसिडरेशन का डिस्प्यूट है तो आपको प्रूव करना ही पड़ेगा क्या कंसिडरेशन, सीधी सी बात। ये सारी चीज़ें इसलिए लिखाते क्योंकि एक बार रिकॉर्ड देखते हैं तो चीज़ें जो दिमाग में आती है उसको कैप्चर करना ज़रूरी है। 28 मार्च को रखिए। The office is directed to make the state of Jharkhand. नहीं ऐसे कुछ, that should be sufficient. आपके आगे
Password case from supplementary list item 6 contempt 0321 of 2025.
That composition amount.
हाँ।
It was first time it is coming contempt case.
नहीं तो आपने बोला ना कि चल रहा है, तो क्या चल रहा है जानना चाहिए। पूछिए जरा
We have received instruction that they have prepared award in the name of.
एक सेकेंड, आप जरा बैठ जाएंगे संजीव जी। आप हैं लैंड एक्विजिशन ऑफिसर हैं, डिस्ट्रिक्ट लैंड एक्विजिशन ऑफिसर रांची, क्या नाम है आपका? अच्छा ठीक है, अपना नाम डिटेल दे देंगे। इनका क्या चल रहा है, कुछ प्रॉब्लम है इनके केस में?
3 legal error और
कोई बात नहीं, और भी होंगे, सबको अपना कर दीजिए, कोई दिक्कत नहीं, सबको नोटिस कर दीजिए।
प्लस एनओसी करके एग्रीमेंट इज अनेक्स्ड विद द रिप्रेजेंटेशन इटसेल्फ, योर लैंडशिप में भी।
नहीं भाई, उनको बुला के पूछताछ कर लीजिए भाई, ठीक है, They will come.
Notarized agreement जब वो लोग दिए तो they will come and they will
They
say
will
the
come
same thing.
and say the same thing or whatever they have to say. अपना आइडेंटिटी चेक कर लेंगे भाई कौन आदमी आ रहा है, आधार और भी आई कार्ड्स आजकल बहुत तरह के हैं, चेक करके आपको जो करना है, कितना टाइम लगेगा आपको इस पैसा को डिस्बर्स करने में?
3 बार नोटिस दिए थे उनको सारा पेपर जमा करने के लिए, तो फिर किसी को ने अपना दिया, उसका सत्यापन के लिए पूर्वांचल भेज चुके हैं।
ठीक है,
अब आ जाएगा हम लोग।
और बाकी लोगों का
उनके 4 हैं, फिर किसी को जो 1 जमा किया है, 3 नहीं किए, उसका अंचल वेरिफिकेशन के लिए भेजे, आएगा तो लोग 1 सप्ताह से 15
और बाकी लोगों को भी तो नोटिस कर देंगे ना, ये पैसा को रख के क्या करेंगे?
बाकी लोगों को नोटिस, क्योंकि फिर किसी को जरूरी से
आप बाकी लोग को भी आप
नोटिस हुआ था।
देखिए ऐसा है ना, किसी को कॉम्पनसेशन देने के लिए कोर्ट के आदेश की ज़रूरत नहीं है, कायदे से आपको खुद ही करना चाहिए, ठीक है। लेकिन चूंकि एक बार कोर्ट में आ गया मैटर, तो कॉम्पनसेशन की बात आ गई। अगर मान लीजिए एंटाइटलमेंट ऑफ कॉम्पनसेशन टू मिस्टर प्रेम किशोर कुजूर इज नॉट इन डिस्प्यूट, तो बाकी भाइयों का भी तो डिस्प्यूट में नहीं होगा ना।
उनके पिता के नाम से, जोएल ब्राउन के नाम से बना था।
ठीक है, ठीक है, तो जो भी उनके आपको वंशावली मिल गई होगी,
वंशावली एफिडेविट दी है, उसका सत्यापन पंचायत से होके आ जाता है, पेमेंट मेरा सब बना हुआ है, आ जाएगा।
आप ही सबको जिनका भी है भाई इसको पेमेंट मत रखिए, पेंडिंग रखिएगा, अपने ड्यू प्रोसीजर के अनुसार जो होता है इसको करके इसको निपटा दे देगा।
15 दिन के अंदर हो जाएगा।
15 दिन बहुत शॉर्ट टाइम है, हम आपको ज़्यादा टाइम देंगे। आप एकदम इत्मीनान से, कोर्ट का कोई प्रेशर नहीं होता है सब चीज़, हम लोग सिर्फ इतना चाहते हैं कि आप अपना काम बढ़िया से करें, ठीक है। इनको दौड़ना नहीं पड़े, किसी भी काम के लिए दौड़ाने का कोई काम नहीं है, ठीक है। अपना काम बढ़िया से करके केस को इंट्रोड्यूस करें, प्रेशर में नहीं आने का है, कोई प्रेशर नहीं है कोर्ट का। मैं आपको ये चीज़ बहुत क्लियर कर रही हूँ, हम लोग प्रेशर नहीं देते किसी को। आपको जो काम करना है आप तक कर लीजिए, किसी का क्लेम रिजेक्ट करना है तो रिजेक्ट कर लीजिए, हमें इसमें कोई मतलब नहीं, ठीक है। लेकिन एफिडेविट चूँकि आ गया था रीट पिटिशन में कि आप पेमेंट करेंगे, तो देयर इज़ नो रीज़न फॉर रिजेक्शन, इज इट? ठीक है, लिखिए कंटेम्प्ट सिविल 321 of 2025. The district land acquisition officer Ranchi, namely such and such, is present in the court and is also represented by the learned counsel for the state. It has been informed to this court that certain steps have been taken for the purposes of complying the orders of this court, and he submits that needful will be done within a period of 15 days. However, the matter is directed to be posted on 4th of April. The compliance report along with any order, कोई order to draw करना पड़ेगा आपको, along with the order be filed before this court by 28th of March. 28 मार्च तक आप कर देंगे?
अपीयरेंस उनका
आप अपने सारे भाई बंधु को लेके जाइए, इस काम नहीं हो पाएगा।
वो लोग बाहर काम करते हैं, इसीलिए वो लोग ने एक नोटराइज्ड एग्रीमेंट जो है
ऐसा नहीं चलेगा ना,
उनको बोल देंगे कि एक बार अपीयर
आना पड़ेगा, उनको आना पड़ेगा
विदिन 15 डेज।
देखिए आप सुन लीजिए, इनके ना भाई जो लोग हैं वो लोग कहीं बाहर काम करते हैं, कोई डेट आप बता देंगे, इनसे डेट पूछ लेंगे, उस दिन जो है उनको एक डेट फिक्स कर दीजिए उनके अपीयरेंस का, या कोई एक डेट में सबको ले जाकर फिजिकली थोड़ा सा अपीयर होना जरूरी है,
फिजिकली प्रेजेंट होकर स्टेटमेंट्स रिकॉर्ड
also from daily list for final store item 1 WPS 2907 of 2014.
This matter pertains to promotion to grade 4, that is graduate trained scale, of a teacher who was interested in working in Bokaro district. Since retired by that with effect from 31st December 2022. Very briefly, my lords, I have paid my main prayer is for grant of promotion to grade 4, that is graduate trained pay scale teachers. There are 7 grades, my lords, in elementary school. 1, 2, 3, they all belong to matric grade, my lord. Then, my lord, 4 and 5, they belong to graduate trained scale, and 6 and 7, headmaster levels. So 4 is a promotion, regular promotion, my lord. It is not upgradation of a scale, it is a regular promotion. And grade 4, Roman 4, my lords. Now, my lords, a gradation list. There is 1993 promotion rules for elementary teachers of Bihar, which has been duly adapted by the state of Jharkhand, my lord, after reorganization of Jharkhand. And we are following till date, no other promotion rule has been framed, my lord.
Do you have a copy?
My lords, may kindly have a look to the counter affidavit
You have
file
only annexed the extract. I want to see the copy.
of the rules, my lords. My lords, that has been annexed, my lord.
Entire rule has been annexed.
Yes, of the counter affidavit, my lord. They have filed a counter affidavit. And page 23, my lords, although it starts from page 21 of their counter affidavit, first counter affidavit. प्रारंभिक विद्यालय शिक्षक प्रोन्नति नियमावली. Page 21, my lords, that is the first page. So, my lords will kindly find that there are in all, my lord, 8 grades of teachers, and grade 4 and 5 at serial 6 and 7, my lord. That is a Snatak Prashikshit Vitanman Kala and Vigyan. 5 is also a Snatak Prashikshit Vari Vitanman, selection. Now,
कहाँ पढ़ रहे हैं?
my lord,
Page number?
page 21 of their counter.
Page 21.
Yes.
Grade 4.
इसमें
आपको grade 4 promotion चाहिए.
grade 4 चाहिए. Grade 4 जो है वो promotion चाहिए. Now इसी में I will draw my lord's kind attention to rule 10, my lords. That is at page 23. Page 23. Rule 10, प्रोन्नति आदेश. वरीयता सूची से जिला शिक्षा स्थापना समिति द्वारा उपलब्ध पदों के विरुद्ध प्रोन्नति संबंधी आदेश निर्गत किए जाएंगे, जो जिला शिक्षा अधीक्षक एवं उप विकास आयुक्त के संयुक्त हस्ताक्षर से निर्गत किया जाएगा. So, promotion order, it has to be issued on the basis of, my lord, gradation list. Varita Suchi, that is gradation list, my lord. Now I will show the gradation list of teachers from my writ petition that may be found at page 26, annexure 2 of my writ.
Yes, 26.
Now, page 26, my lord, annexure 2. My lord, the topic says grade 4 विज्ञान में प्रोन्नति के लिए अर्हता रखने वाले शिक्षकों की वरीयता सूची वर्ष 92 से 2004. So this is the gradation list. And my name appears at serial 6, my lord, Hafiz Ansari, serial 6.
Yes.
Now there are many teachers below me, and
This is the final gradation list.
yes, this is final gradation list, my lord. This was now gradation list, my lord. Unless something very unusual happens, it is same, my lord. Even after a year or 2 years, unless there is some departmental proceeding against me. So that is fixed from the very time of appointment, my lord. So this is the gradation list, and thereafter they issued promotion orders, my lord, which may be found at page 29, annexure 3.
Yes.
Annexure 3, 29, it starts from 29, and 30 is the list, my lord, at page 30. there my lords will find that Shambhu Prasad Singh, he was at 9, serial 9. This may kindly be taken note of. He was junior in the serial 9 of the list which had earlier shown.
Yes.
Then my lord, next is Sri Prabodh Kumar Vishwas at serial 3. He was at serial 14 in the gradation list. Prabodh Kumar Vishwas. Only 3-4 names I want to show. Then Sri Churamani Ram Mahato. He was at serial 10. His name appears.
So serial number 9, serial number 10. और कौन और दो?
एक 9 पर, एक 14 पर, एक 10 पर, एक 13 पर और एक 12 पर. इतने
9,
लोग
10 ऐसे ऊपर नीचे मत बताइए. 9, 10,
12, 13, 14.
12,
13,
14.
ये सभी लोग हमसे जूनियर थे ग्रेडेशन लिस्ट में. इन स्पाइट ऑफ दिस फैक्ट माय लॉर्ड,
2009 में इनको प्रमोशन मिली.
इनको 2009 में प्रमोशन. So I am basically agreed that this is an infraction of the promotion rules, my lord. Now thereafter they filed a counter. My lords may kindly come to their counter. In para 8, my lord, they say of the counter affidavit, first counter affidavit.
ये जो promotion order है, you are agreed by the promotion granted to the juniors. And you are agreed by the fact that promotion has been granted to the juniors,
but I have been deprived, which is in the teeth of my lord.
Promotional post का कुछ fixed vacancy होता होगा ना?
किसका?
Promotional post का.
हाँ तो वो तो promotional जब नीचे वाले को दे दिया ये लोग, हाँ vacancy के against में ही होगा. If I am fulfilling the qualifying years of service, 5 years, and other eligibility, my lord, I am a graduate.
And the promotion will be against vacant sanction post. Correct?
Very, very correct.
So if you want promotion, then they are to be shifted. किसी का तो promotion खत्म होगा ना?
तो अब तो हम रिटायर कर गए, अब तो हमको नोशनल ही मिल सकता है.
तो 2014 से रेट चल रहा है.
हमको तो
किसी का तो promotion order को आपको challenge करना था ना. इसमें हमको कोई private respondent नहीं दिखा. इसीलिए हम आपसे पूछ रहे हैं. क्योंकि अगर 4 पोस्ट है, मान लीजिए 10 पोस्ट है प्रमोशनल पोस्ट, 10 आदमी जो आपसे जूनियर है उनको प्रमोशन कर दिया, आपको छोड़ दिया. तो अगर आपको प्रमोशन चाहिए तो 11 पोस्ट तो नहीं क्रिएट हो जाएगा ना. 10 पोस्ट के भी रहेगा, उसमें जो सबसे जूनियर मोस्ट रहेगा या जो भी आपका पोजीशन रहेगा उनको हटाया जाएगा ना. इसमें तो कोई ऐसा रिलीफ ही नहीं.
और देख लो, और माय लॉर्ड्स जो उनका काउंटर है वो कह रहे हैं कि वी आर कंसीडरिंग. I am aggrieved by their policy, the decision of establishment committee, that how it is a fact, my lord, that someone is likely to be affected, but there are many other posts also. Even I am given the benefit from the date of their juniors. Now, my lord, I can get only notional benefit, my lord. They filed 3 counters.
इन्होंने एक जजमेंट साइट किया था कि प्रमोशनल बेनिफिट नोशनली नहीं मिल सकता. आपने वो जजमेंट देखा होगा, लास्ट ऑर्डर में रिकॉर्डेड भी. ऑर्डर शीट में हमने डाल दिया था क्योंकि आप एब्सेंट थे लास्ट टाइम, सोचे कि आप पढ़ के आएंगे.
ये तो मेरी गलती नहीं है, माय लॉर्ड्स. ये मेरी गलती नहीं, ड्यू टू लैप्सेस on their part, my lord, in infraction and divorce the rules, my lord, then always, my lord,
then I can give you some compensation. Promotion कैसे देंगे?
my lord wishes वो हमेशा.
क्योंकि दो चीजें हमको समझ आ रही. पहला चीज कि आपने प्रमोशनल पोस्ट तो ज्वाइन नहीं किया, आपको प्रमोशन मिला ही नहीं और आप रिटायर कर गए.
हाँ.
ठीक है. तो नोशनल प्रमोशन देकर आपको पेंशन रिवाइज करने का कोई स्कोप नहीं दिख. That will be an order against the provision of law and the pronouncement of the judgment by the Honorable Supreme Court. Secondly, अगर आपको किसी की जगह पर प्रमोशन आपका होना चाहिए तो वो पार्टी नहीं है और आपका ये केस नहीं है कि उस दिन जो है और वैकेंसीज अवेलेबल थी तो आप हमको एडजस्ट कर सकते हो. वैसा आपने केस नहीं.
Counter stand. Promotion normally, notional promotion is not given in normal course, normal circumstances. But here I have made a specific
अरे
case,
भाई,
made out a
किस
specific
वैकेंसी के अगेंस्ट में हम आपको एडजस्ट करते हैं? There has to be a vacant sanction post.
case. It is their job. I don't have the
तो
figures.
किसी वही ना भाई,
Then
किसी
my-
के प्रमोशन को तो सेट असाइड करना पड़ता ना.
My lord, if vacancies, sometimes vacancies exist also. So my lord, the respondents can, in other cases also which I have fought, my lord, my one case was dismissed by CAT that I could not explain the vacancy. But that is not within my control, my lord. Vacancy is always with the department, the district education establishment committee. I only want to show to my lords how they are shifting their stance every time. In the first counter they say that it is under active consideration, para 10. My lords, kindly see for a moment.
नहीं, एक चीज और, ये जो इन्होंने ये ग्रेडेशन लिस्ट बनाया है, ये फाइनल
2000 together 3 gradation lists बनाते हैं 2005, 2009 and 2014. 2005 वाला जो लीडरशिप जिसमें petitioner नाम सीरियल नंबर 6 है, वो फाइनलाइज हुआ 14/7/2009 को. 2005 वाला लिस्ट 14/7/2009 को फाइनलाइज हुआ.
2009 को फाइनल.
That is annexure 3 of the writ petition.
ये प्रमोशन थोड़ी
Promotion
ग्रेडेशन लिस्ट थोड़ी है.
Gradation
ये तो प्रमोशन ऑर्डर.
promotion list.
ग्रेडेशन का फाइनल हुआ.
फाइनलाइज करके as per rules 9, 10 जो भी ऑब्जेक्शन आना था.
अरे भाई, ग्रेडेशन लिस्ट अगर फाइनलाइज किए होंगे तो फ्रेश ग्रेडेशन लिस्ट बनाए होंगे ना. कहाँ है वो?
लिस्ट नहीं बट वो फाइनल प्रमोशन लिस्ट.
My lord, they have filed one counter in which they have supplied their list, gradation list, latest, my lords.
That is
I want to
2014 list.
2014 की बात ही नहीं कर रहे हैं हम, तो यहाँ पर हैं 2009 में.
9
2009 के पहले कौन सा ऐसा ग्रेडेशन लिस्ट था?
2005.
2005 यही तो है,
हाँ.
जिसमें ये सीनियर है. फिर क्या?
इनएडवर्टेंटली वो वहाँ पे मिस आउट हो गया था.
हाँ, तो कौन रिस्पॉन्सिबल है इसका?
रेस्पोंडेंट्स भी एंड अलॉन्ग साइड petitioner का भी फॉल्ट है बिकॉज़ एक बार अगर annexure 3 देखा जाए page 30 the relevant part डॉक्यूमेंट्स में प्रोन्नति नियमावली 93 विभाग यदि सूचना संख्या सच की कंडिका 14 के आलोक में इस नियमावली के नियम 10 के अधीन निर्गत आदेश से विक्षुब्ध शिक्षक आदेश निर्गत होने के 30 दिनों के अंदर प्रमंडलीय आयुक्त के समक्ष अपील कर सकेंगे. This list was prepared in 2009 wherein his name was omitted in leadership due to inadvertence. It was omitted. Petitioner had a time of 30 days, but still he comes up after a period of 5 years that my name is not in the promotion list.
And this promotion order is under challenge? No.
This is not the
This promotion order is also not under challenge.
This order.
I have simply sought for a mandamus minor that from the date juniors have been promoted. Now, if my lords will see kindly one order passed by this honorable court, my lord. Order dated 6th February 2020. 6th February 2020. I may be permitted to read it out, my lords. Pursuant to order dated 17/10/2019 passed by this court. This is 6th February 2020. May I read it out?
एक second. Yes.
Pursuant to order dated 17/10/2019 passed by this court, the respondent authorities have taken steps for consideration of case of petitioner for promotion and gradation list has been prepared and the petitioner name finds place at serial 11. This is another gradation list. However, nothing has been mentioned in the counter as to why the juniors to petitioner have been considered and granted promotion. Mr. So, learned counsel to the respondent submits that petitioner has not challenged the gradation list. This contention of the respondent is not acceptable to this court, as there was no occasion to challenge the gradation list as the name of the petitioner finds place in the list which was approved and considered for grant of promotion. The respondents are directed to file a specific reply as to why the petitioner was discriminated and juniors to petitioner were granted promotion, rehearse the promotion rules 93 and without taking into consideration the seniority of the petitioner as per the gradation list. My lord, in compliance of this, my lord, again they file one second supplementary affidavit, and I will draw my lord's kind attention to para 17 and 18. This is a second supplementary affidavit. In the first, my lord, supplementary counter affidavit, in para 4-5 they annex another gradation list. First, my lords may kindly take up this supplementary counter affidavit. And para 4-5, what they say, para 4, that it is humbly stated and submitted that a gradation list for promotion of primary teacher to grade 4 is already prepared by the Office of District Superintendent for Education, Bokaro, in which name of petitioner Muhammad Hafiz Ansari is at serial level. That from the aforesaid facts it is clear that case of petitioner for promotion to post of grade 4 is under active consideration. Now here, my lord, they have annexed one gradation list that may be found at page 8, and my name appears at seal number 11, Hafiz Ansari. So again, they have given an undertaking before this honorable court. After that, this order was passed, my lord, 6th February 2020, and they filed another second supplementary counter affidavit. They take a U-turn. I will draw my lord's kind attention to para 17 and 18. A lot of things have been mentioned, but only relevant portion, my lord. 17 and 18 at internal page 8 of the last second supplementary counter. Para 17, I am reading, my lords, that it is humbly stated and submitted that petitioner was thereafter included in the gradation list prepared in 2014 and finds place in serial number 11 and Annexure A to supplementary counter affidavit filed on 3/2/20. However, he couldn't be given the benefits of grade 4 since none of the teachers have been granted grade 4 benefits based on the said gradation list. In fact, it is pertinent to mention that none of the teachers in the district have been granted grade 4 benefits after 2009. The promotion which I have shown in my writ petition, I was eligible in 2009. Again in 18, say my
Is
lord.
there any explanation on your part to leave out the petitioner at the time of grant of?
There is no such explanation.
Then you give him notice.
Only
You have to give him notice.
leadership that has to be adjusted.
What adjusted?
Leadership, the only fact which has been.
It is not your case that there was no vacancy. You have also not made out a case that there was no vacancy.
After 2009, there was no vacancy.
From where do you say this?
Leadership, para 17 itself has been stated that. In fact, it is pertinent to mention that none of the teachers in the district have been granted grade 4 benefits after 2000.
That's right. You have not granted. You don't say that there is no vacancy. That is not your case. It was just my query. I just wanted to know from you. Yes?
Yes, Rule 6 of the limited rules itself says that benefits would be granted subject to availability of post. It says that after 2009, that no such benefits.
There has been no benefit has been granted. That does not mean that there was no vacancy. दोनों सेंटेंस में फर्क नहीं है. ये आपको समझ नहीं आ रहा. It is not your case that there was no vacancy. जब भी वैकेंसी था, ये लोग कभी ना कभी तो रिटायर हुए होंगे ना. जब भी वैकेंसी था, इनको एडजस्ट करिए. आप अपना वैकेंसी पोजीशन देखिए, इनको एडजस्ट करिए. इंस्ट्रक्शन की जरूरत नहीं, ऑर्डर की जरूरत है. इंस्ट्रक्शन से कुछ नहीं होगा. 2014 से केस चल रहा है यहाँ पे इंस्ट्रक्शन.
This also has to be kept in.
I will take care of that judgment. Don't worry about it. You cannot have a premium on your own latches.
I accept that, leadership. But one more thing which I would like to point out, leadership, the representations which have been filed by the petitioner, that is dated.
You are throwing the burden on the petitioner.
No, leadership.
Yes, that he did not raise any objection.
But he has come up after a period of 5 years.
पढ़ाएंगे टीचर की आपके पीछे पीछे घूमते रहेंगे.
Leadership, that objection has been raised after a period of 5 years.
Maybe. Yes, you are passing the burden on the petitioner.
I accept that.
On the face of it, his name is at the higher
list of 2000.
higher list.
Yes.
Then
One thing only, leadership, which I would like to point out. the representations were made by the petitioner on 4th of
Why did you make a projection before this court in 2014 that you are considering dismiss?
which is after the representation which was filed, the claim of the petitioner was relevant documents were called for, and subsequently a accreditation list was prepared. As per the affidavit which has been stated, that a list was prepared and his name was placed at serial 11 of the accreditation list of party.
Yes.
But further, it has been stated in the affidavit that no, any of the teachers are not given the benefits of grade 4.
The illegality was done in 2009 itself. You have no explanation whatsoever. And what is the explanation in the first counter affidavit regarding this leaving out the petitioner? Kindly read your first counter. Let us see what explanation have you given.
The first affidavit at para 9 we have stated that
Yes.
at para 9 we have stated that at present there is only 11 posts vacant in grade 4 and work to prepare gradation list is under progress, and no sooner the said gradation list shall be prepared into law and approved by the District Education Establishment Committee Zariba for equal, and after taking the due process of law and rule made thereunder, promotion shall be granted to the eligible candidates as per the gradation list referred above.
So vacancy was there? When you filed this affidavit, the vacancy was there?
It was there.
Yes, then?
Subsequently, 2000.
Para 8 is also important of this counter, first counter. It may kindly be my seen that the answering respondent is stated and submitted that it is not out of place to mention here that the authority concerned are always ready to consider the case of all teachers, including the petitioner for promotion in promotional post, in accordance with law and rule made thereunder. The answering respondent, my letter sentencing by the petitioner to file these statements, claims, certificates. That also I have filed my notes. So they have this amounts to an undertaking.
What is the explanation for not giving him promotion in the year 2009? What is your explanation for that? In 2014, you are considering it's okay. What is the explanation for not giving him promotion in 2009?
There is no clear.
No clear cut. There is no explanation.
There is no explanation.
Then?
It has only been stated that the petitioner liability has been shifted. I will have to do that. Liability has been shifted.
Subject to my Lord's pleasure, I can pray that the direction may kindly be given, this can be disposed of, giving some time limit, my Lords. Some benefit I should get, my Lords. It is a fact that the case is very old one.
नोशनल प्रमोशन से आपका पेंशन रिवाइज हो जाएगा।
हम नोशनल से हो जाएगा, आपको एरियर नहीं भी मिले, हमको जब से ये दे नोशनल तो हमारा पे फिक्सेशन थोड़ा बढ़ जाएगा, और जिस दिन से होगा पे फिक्सेशन उस दिन से एक मिलेगा। माय लॉर्ड्स में पास एन ऑर्डर, ये सब्जेक्ट टू माय लॉर्ड्स प्लेजर कि हमको एरियर में ही बेनिफिट होता है।
एरियर हम नहीं दे सकते।
हाँ, आई एम नॉट कॉजिंग अ लॉस टू गवर्नमेंट एक्सचेकर माय लॉर्ड, आई डोंट पे। Whatever is now for my fault or their fault, apparently it is their fault. Article 14, 16 come into play, my lord, and the The rule 309 framed under provision 309. So I am only praying, my lord, if notional benefit is also given, then naturally
Some
right,
benefit in the pension.
some benefit
In the post-retirement benefits.
वो भी हो जाएगा तो he is clinging his hope on the lawyer.
अब जजमेंट तो लेके नहीं आए कि जूनियर का प्रमोशन मिल जाता तो नोशनल
तो
बेनिफिट मिल
दे
रहा
देंगे,
कब दे देंगे?
मंडे को दे देंगे
आज नहीं करें आपको ऑर्डर?
ना तो जजमेंट्स तो नहीं
हम आपकी तरह विद्वान नहीं है ना, हमको नहीं पता.
My lords come across a variety of cases and there is lot of empowerment.
देखिए ना ही तो हम मेमोरी से चलते हैं, ना ही अपने किसी भी नॉलेज से चलते हैं. जो सामने आता है उसको देख के ही ऑर्डर.
But very minor pointed queries my lords make and specific.
देखिए.
After all, this is a constitutional court, my lords. हमें को भी अच्छा लगता है.
In the WPS number 2907 of 2014, for the learned counsels appearing on behalf of the parties, this petition has been filed for the following relief. The learned counsel for the petitioner has referred to the gradation list prepared way back in the year 2005 as contained in Annexure 2 and has submitted that in grade 4, the name of the petitioner appeared at serial number 6 and name of persons appearing in serial number 9, 10, 12, 13 and 14 were granted promotion to grade 5 post.
4.
Sorry.
Graduate trained discipline.
तो ये पे grade 4 विज्ञान प्रोन्नति लिखा
हाँ,
हुआ है.
that grade 4 science. At that time, there were division science, art.
ये ऊपर grade 4 क्यों लिखा हुआ है? grade 3 से grade 4 जाना था ना आपको.
हाँ, तो grade 4 में promotion हुआ. Grade 4 is actually graduate trained discipline. I was already.
नहीं नहीं, आप annexure 2 में grade 4 क्यों लिखा हुआ है? प्रोन्नति के लिए. अच्छा अच्छा. ऐसे लिखिए. Annexure 2 में ऊपर grade 4.
प्रोन्नति के लिए.
अच्छा. The learned counsel has submitted that for the purposes of grant of promotion.
To grade 4.
To grade 4. A gradation list was prepared
of eligible teachers.
Of eligible teachers, and the name of the petitioner appeared at serial number 6.
Nice.
And but the persons who were at serial number 9, 10, 12, 13 and 14 were granted promotion to grade 4 wide order contained in memo number 509 dated 14/7/2009, but the petitioner was left out. He submits that the petitioner had filed a representation before the District Education Officer Bokaro on 4/6/2014, not only for grant of promotion to grade 4, but for further promotion to grade 7.
But later on, 7 I withdrawn that.
But during the course of argument, the learned counsel for the appellant has submitted that he would not be pressing for his grievance in connection with promotion to grade 7.
So,
he submits that in spite of representation, when no action was taken to redress the grievance of the petitioner, the present petition was filed before this court on 26/2014. He has submitted that a counter affidavit was filed initially on 12/1/2015, wherein there is no explanation for not granting promotion to the petitioner to grade 4, although juniors to him were promoted. But at the same time, in the affidavit, it was mentioned that as on that date, there were 11 vacant posts in grade 4 within bracket BSc trained, and work to prepare gradation list was under progress. And needful will be done after adhering to the due process, and promotion shall be granted to the eligible candidates as per gradation list. Which was prepared by letter number 1319 dated 21/8/2014. The learned counsel submits that the necessary documents in connection with grant of promotion was furnished by the petitioner, but no decision was taken, and an order dated 6/2/2020 was drawn by this court. Wherein the counsel for the state had submitted that the petitioner had not challenged the gradation list, but such a contention was rejected by this court as there was no occasion to challenge the gradation list, as the name of the petitioner found place in the list which was approved for consideration for grant of promotion. And a specific order was drawn as to why the respondents were directed to file specific reply as to why the petitioner was discriminated and juniors to the petitioner were granted promotion, divorced the promotion rules of 1993, without taking into consideration the seniority of the petitioner as per the gradation list. Pursuant to the order dated 6th of February 2020, a counter affidavit was filed.
This is second supplementary counsel.
The council has submitted that a second supplementary counter affidavit was filed. A supplementary counter affidavit.
This is second supplementary. They had earlier filed supplementary counter. Thereafter, this order of honorable court was passed, my lord, which my lord have just now mentioned. And then, my lord, they filed this specific counter.
A second supplementary counter affidavit was filed before this court, mentioning therein that in the gradation list prepared into 2014, the petitioner's name was in serial number 11, but the promotion was not granted to the petitioner as none of the teachers were granted grade 4 benefit after 2009. It was also stated in the affidavit that the petitioner has attained the age of superannuation on 31/12/2022. A further stand was taken in the counter affidavit that the petitioner never raised any objection to the promotion granted in the year 2009, although which was granted by memo number 509 dated 14/7/2009. The learned counsel has submitted that the respondents have no explanation for not granting promotion to the petitioner, and are unnecessarily passing the burden upon the petitioner by stating that the petitioner ought to have raised objection with regard to the promotion of others. The learned counsel submits that when on the face of the gradation list for grant of promotion prepared by the respondents, they were duty bound to act as per the gradation list, which in the entire records of this case is not in dispute. Correct?
And as per Rule 10 of the promotion rules, having statutory force.
The learned counsel submits that as per Rule 10 of the promotion rules,
Promotion is to be granted on basis of gradation list.
the promotion has to be granted on the basis of gradation list. The respondents have violated the rules and therefore the petitioner is entitled for the relief as prayed for in this petition.
One thing which was skipped leadership, annexure C to the counter affidavit. I had skipped leadership. It was my mistake. Second gradation list was prepared in 2008 on 27/5/2008. That was the first gradation list in 2005. Second list was prepared in 2008. His name was not there. That list was finalized and on the basis of which the 2009 promotion list was prepared. Annexure C to my counter affidavit. Second supplementary counter affidavit.
Annexure C. कहाँ डेट है इसमें?
Annexure C lecture at specific at para 10 that has been mentioned 27/5/2008.
To the second supplementary contract.
Yes, Lecture.
आपका स्टेटमेंट क्या है?
Para 10 which is relevant start from para 8 that a gradation list of that a gradation list of all the teachers who fulfilled the eligibility for grant of grade 4 promotion was finalized by the District Education Establishment Committee in its meeting held on 14/6/2005. The name of the petitioner finds place in the said gradation list at serial number 6. That however it is pertinent to mention that none of the teachers were granted grade 4 benefits based on the said gradation list. That is duly stated and submitted that again in the year 2008 a fresh gradation list being gradation list 2 of all graduate science trained teachers eligible for promotion to graduate to grade 4 was finalized, which was approved by the District Education Establishment Committee in its meeting held on 27/5/2003. That the proceed list after being approved by the District Education Establishment Committee in its meeting held on 27/5/2008 was sent to the office of respondent number 7 by letter number 85 dated 27/2/2009. Thereafter the list was granted approval by the respondent number 4, that is Regional Deputy Director Education North Chotanagpur, and the same by letter number such and such. So a second list was released. That has I had that is my mistake. But the second list which was prepared on the basis of which promotion was granted, even in that list his name was not the leadership. If the petitioner is relying upon the list which was prepared in 2005, none of the teachers were given promotion on the basis of list of 2005 but of 2008 leadership. Further, as per the Rule 9(1) of the elementary rules leadership.
ये कब बना, कहाँ से पता चला? अच्छा, समिति द्वारा दिनांक इतना अनुमोदन प्राप्त हो चुका 18/12/2008, राइट? एंड ये कब बना? 27/5/2008. The learned counsel for the respondents, on the other hand, while opposing the prayer of the petitioner, has submitted that, as per the second supplementary counter affidavit, the promotion was not granted on the basis of the gradation list prepared in the year 2005, as contained in Annexure 2 to the petition. But the same was granted on the basis of gradation list prepared in the year 2008. He has referred to paragraph 8, 9, 10 and 11, 10 to 12. 10 to 14, 10 to 15 of the second supplementary counter affidavit dated 23/2023 and submits that it is true that in the meeting held on 14/6/2005, the name of the petitioner was at serial number 6, but a revised gradation list was prepared and thereafter it was finalized in the meeting held on 27/5/2008, which was followed by letter number 85 dated 27/2/2009 and ultimately approved by the Regional Deputy Director of Education by letter number 332 dated 4/3/2009, and the name of the petitioner did not find place in the final gradation list which was prepared in the year 2008. He submits that the final gradation list of the year 2008 was followed by the order of promotion as contained in memo number 509 dated 14/7/2009, and ultimately, and in the said memo also there was a clause that if anybody has any objection with regard to the gradation, with regard to promotion, one can raise objection, but the petitioner did not raise any objection at the relevant point of time and filed a representation only in the year 2014, claiming promotion to grade 4 as well as further promotion to grade 7. The Learned Counsel submits that the gradation list which is being relied upon by the petitioner of the year 2005 is of no consequence. He has submitted that in such circumstances, the petitioner has already attained the age of superannuation and there is no question of no mandamus be issued. He has relied upon the judgment passed by the Honorable Supreme Court reported in Honorable Supreme Court in civil appeal number.
Yeah. SCC.
Reported in 2024 SCC on line 3512 and has submitted that the Honorable Supreme Court has reiterated that no retrospective promotion can be granted, nor can any seniority be given on retrospective basis from a date when an employee had not even been born in the cadre. The Learned Counsel has submitted that as the petitioner was not granted promotion in terms of the gradation list of 2008 and therefore which was never challenged by the petitioner, 2008 which was never challenged by the petitioner, and therefore there is no question of and therefore there is no illegality in the action of the respondents. There is no question of grant of any retrospective or notional promotion to the petitioner in the facts and circumstances of this case. That's all. After hearing the Learned Counsel's appearing on behalf of the parties and upon going through the materials on record, this court finds that apparently the petitioner was claiming promotion as per the writ petition on the basis of gradation list prepared in the year 2005. And the grievance of the petitioner was that as per the gradation list of 2005, his juniors were granted promotion by memo number 509 dated 14/7/2009. But the petitioner was left out. It is important to note that the memo number 509 dated 14/7/2009 has not been challenged by the petitioner nor any of the persons who have been granted promotion who were juniors to the petitioner have been made party in the present proceedings. This court further finds that an order was drawn by this court on 6th of February 2020, wherein the objection of the state that the petitioner had not challenged the gradation list was rejected in view of the fact that, as per the writ records, the petitioner was claiming promotion on the basis of the gradation list of 2005. Further, an order was passed directing the respondents to explain as to why the juniors to the petitioner has been granted promotion and the petitioner has been left out. The supplementary counter affidavit filed by the respondents, second supplementary counter affidavit filed by the respondents revealed that the promotion was not granted on the basis of gradation list of 2005, but the same was granted on the basis of gradation list of 2008, in which the name of the petitioner did not appear. The entire background under which the promotion order was issued, contained in memo number 509 dated 14/7/2009, has been given in the second supplementary counter affidavit. Thus, the very basis of the claim of the petitioner that the petitioner was entitled for grant of promotion as per the gradation list of 2005 stands demolished by virtue of the second supplementary counter affidavit filed by the respondents. No rejoinder has been filed by the petitioner to the second supplementary counter affidavit, nor the petitioner has taken any steps to challenge the gradation list which has been brought on gradation list of 2008 which has been brought on record. The fact remains that the petitioner has already attained the age of superannuation. Considering the totality of facts and circumstances, this court is not inclined to grant the relief as prayed for by the petitioner and finds no merit in this petition, which is accordingly dismissed.
Orders from daily list item 10, first appeal 43 of 2012.
This matter has been come after remanding from the Honorable Supreme Court.
इसको जो है ना तो इसको ऑर्डर शीट हो गया। कोई बात नहीं, ऐसा वॉल्यूम से नहीं डरते, ठीक है ना। अब बताइए इसको करना कैसे?
मैडम इसमें बहुत सा आईए है, सिंगल आईए है जिसका हमको जवाब रेडी हुई थी, इट इज प्रिपेयर्ड टाइम फ्री।
मतलब आप ये सब क्या कर रहे हैं? आइए कब का? व्हाई डिडंट यू फाइल इट अर्लियर?
नहीं, वो डिस्पोजल हो गया था मालूम, उसके बाद सुप्रीम कोर्ट गए, सुप्रीम ऑनरेबल सुप्रीम कोर्ट से
ये मैटर टेक अप हुआ था ना।
उसके बाद ये हम लोग चूंकि हम लोग एक ही आईए का हमको जवाब देना है, दैट वी हैव प्रिपेयर्ड, वी कुड नॉट फाइल।
व्हाई डिडंट यू फाइल इट?
बिकॉज़ माय लॉर्ड हमारा है वेटिंग के लिए जाता है हेड ऑफिस।
कौन है आप?
सहारा इंडिया है माय लॉर्ड, वहां से वेटिंग होकर के आया है, उसके बाद उनके अफसर
टाइम लेने का जो ये सब जो आपका मैकेनिज्म है ना, यहाँ चलने वाला नहीं है।
अपार्ट फ्रॉम दैट ऑल द आईएस कैन बी डिस्पोज्ड ऑफ योर, क्योंकि ये आईए एडिशनल एविडेंस के लिए डाले हैं, जिनको हम लोग जो यहाँ पे एडिशनल एविडेंस के लिए डाल रहे हैं उनको हम लोग ऑब्जेक्ट कर रहे हैं। अपार्ट फ्रॉम दैट 12
आपका द लॉ इज वेल सेटल्ड। फर्स्ट अपील में सारा का सारा एडिशनल एविडेंस एट द टाइम ऑफ फाइनल हियरिंग ही कंसीडर। जिसको जो ऑब्जेक्शन फाइल करना है कर दीजिए, नहीं करना है मत करिए। ठीक है।
अपार्ट फ्रॉम दैट ऑल अदर द आईएस, आई एम जस्ट
आपका ये एडिशनल एविडेंस के लिए फाइल करना चाहते हैं?
हम नहीं फाइल कर रहे हैं।
आप क्या चीज का
अपोजिट पार्टी फाइल किए हैं इसमें एडिशनल एविडेंस के लिए, एम फॉर्म को लेके आए हैं फोटोकॉपी, हम लोग उसको ऑब्जेक्ट कर रहे हैं। अपार्ट फ्रॉम दैट यस्टरडे आई हैव रिसीव्ड one supplementary affidavit by one of the respondent in which the basis of the case is based on the M form that has been found false, saying that it has never been issued by the CEO. That's why I am saying कि apart from
आप M form लेके आए हैं?
नहीं वो नहीं आए, जो उनके तरफ से है ये
किसकी तरफ से M form
on behalf of respondent number 21.
21 who is representing respondent number 21?
Me.
You are representing 21? Yes.
So my says that Lord, already by this order dated, Your Honor, be pleased to accomplish the pleading And in pleading, I have always made addition of party under order 1 rule 10 of the CPC. And now no pleading is there in the code below. Now no pleading, and that's why I have already filed the remand petition before your lordship.
Remand petition?
Because additional evidence is governed by order 41 rule 27 law. Now subsection 1A says that unless there is some flaw on the part of the trial court, how additional evidence will be stated and decided here? That's why remand is necessary.
No,
And in form I have brought, Lord, and so many petitions are also pending here.
Additional evidence is to be considered at the appellate stage, and there are judgments that it has to be considered at the time of final.
Well, I am saying, lordship telling that it has to should know, but unless subset by A and AA be remediate there in the code below, if there is any flaw, then additional evidence comes out. But I have been made necessary party number 21, but no pleading before the court below. And execution
by which order you have been made party?
By appellate court.
By appellate court?
First appellate court I was made. And that was under order rule 10.
So,
and rule 10 if I have been made necessary party, rule 4 says that I have been given a defense there in the court below. That's why I have filed this petition. And in form I have already it has been held that it is false. Now where it will be put? I have already, that is been found by order by concerned revenue department on 2/2/24 that I have filed. Of course my friends.
Revenue department will decide whether it is a forged document or not.
No, that is pending in the court below, na?
Yet it has not been said that is forged. It is only said that has not been issued by each office. That is the report.
And that is also forged also held. That has been forged. Naturally, it will be
So let us take one by one, right? Let us take one by one. First IA, बताइए कौन सा ऐसा IA जो आराम से disposal हो सकता है?
This IA number है my lord.
बताइए.
5043 of 2020.
5043 of 2021.
My lord.
What is it?
ये respondent number 1 to 9 किए थे contempt proceeding initiate करने के लिए respondent number 20 to 22. Now they have been deleted. State respondent they have been deleted by order dated 12/12/2024. तो ये कंटेम्प्ट ड्रॉप हो सकता है. ये जो है ये इन्फ्रक्चुअस हो गया है, इसको डिस्पोजल किया जा सकता है.
बताइए कंटेम्प्ट किसकी तरफ से फाइल हुआ था?
रेस्पोंडेंट नंबर 1 to 9 किए.
Where is respondent number 1 to 9?
appearing here.
लिखिए. IA number 5043 of 2020. This petition has been filed on behalf of respondent number 1 to 9. Seeking initiation of contempt proceedings as against respondent number 20 to 22 for alleged violation of order dated 29/11/2019. The learned counsel for the appellant has submitted that respondent number 21 and 22 has been deleted from the cause title by the order dated
12/12/2024.
12/12/2024.
They are 20 and 21.
Sorry?
The respondent number 20 and 21 have been deleted.
इसमें तो 20 to 22.
20-21 जो है वो देखना है.
Respondent number 20 and 21
Yeah,
have been deleted by the order dated
12/12/2024, order number 82.
12/12/2024, order number 82. इसमें कहाँ है? हम ऑर्डर ड्रॉप किए थे
नहीं कोऑर्डिनेट बेंच करवा आगे वेब कॉपी
since nobody is appearing on behalf of respondent number 1 to 9.
स्टेट अपना आगे फाइल किए थे डिलीशन के लिए उनको delete
Respondent number 20 and 21 have already been deleted by order dated 12/12/2024. IA number 5043 of 2020 is dismissed as not pressed. वो आ ही नहीं रहे तो हम लोग को क्या करना? और बताइए नेक्स्ट आइए.
नेक्स्ट है 5055 ऑफ 2020
5055 of
2020
उसका
ये
क्या है?
अर्ली हियरिंग के लिए फाइल किए थे प्रायर टू द ओरिजिनल ऑर्डर पास दैट केम
IA number 5050 of 2020 has been filed for early hearing of this case. The order of remand is dated
the order of remand is dated April 26 2024
26th of April 2024. Accordingly, the interlocutory application is also closed. Okay? Next बताइए.
then 5710 of 2020
5710 of 2020.
ये आर रेस्पोंडेंट नंबर 2 to 9 फाइल किए थे अगेंस्ट रेस्पोंडेंट नंबर 2020 डीसी धनबाद नाउ इन व्यू ऑफ द अर्लियर ऑर्डर जिसमें है डीसी धनबाद दे हैव बीन
क्या चीज के लिए फाइल किए थे?
they have मतलब taking against action against the state university 5710 ये भी रेस्पोंडेंट नंबर 2 to 9 ही फाइल किए
IA number 5710 of 2020 was filed by respondent number 2 to 9 seeking quashing of order dated 6/10/2020 passed in miscellaneous case number 1 of 2020 passed by Deputy Commissioner Dhanbad. Respondent number 21 in the light of the order dated 29/11/2019 whereby this court had directed respondent number 20 to pass necessary orders in accordance with law on the application filed by the respondent number 1 to 9. ना ये लंबा चौड़ा क्या किया है? Basically, it is a matter arising out of injunction.
matter is arising out of the declaration of right title of the suit land. दो ट्री है दत्ताज एंड पाल्स. दत्ताज से हम लोग का आया था. पाल उनका कहना पाल्स है कि दत्ताज जो है पाल को मॉर्गेज कर दिए थे. मॉर्गेज करने के बाद इन एग्जीक्यूशन प्रोसीडिंग वो पाल्स जो हैं वो चले आए थे शेयर में. नाउ दे दिस पाल्स आर द रेस्पोंडेंट नंबर 1 to 9 and rest are their purchasers, and thereafter a state came into the picture saying that that lands belong to the state, neither Datta's nor Park.
ये तो लॉ वेल सेटल है ना. कोई भी डेवलपमेंट अगर ड्यूरिंग द पेंडेंसी होता है इट इज सब्जेक्ट टू द फाइनल रिजल्ट ऑल द डेवलपमेंट्स विच
My lord.
इसमें तो कोई डाउट नहीं है.
इसमें कोई डाउट नहीं है.
ठीक है.
तो बाकी लोग अपने लोग हैं वो लोग आइए डालते गए हैं अपने स्टेज में
पहले इसी आइए
जी.
ठीक है. इसीलिए इस आईए का क्या रेलेवेंस है आज?
कोई नहीं, मेरा है भी नहीं, इसीलिए कहा कि मालूम इसको जो है डिस्पोज किया जा सकता है. अकॉर्डिंग टू मी इट कैन बी डिस्पोज्ड ऑफ.
मिसलीनियस केस का कोई ऑर्डर अगर उनको चैलेंज करना है तो उनको प्लेंट या जो रिटन स्टेटमेंट जो भी है वो अमेंड होगा ना. ये मिसलीनियस पिटीशन से कैसे चलेगा?
दैट इज माय प्रेयर.
ये रिट पिटीशन थोड़ी है कि एक आईए फाइल कर दिया हो.
दैट इज माय सबमिशन बिफोर यू लॉर्डशिप कि वो आईए फाइल कर दिया और सारा आईए करते all these IAs are
since nobody is appearing on behalf of respondent number 2 to 9 and the respondent number 21 has already been deleted from the cause title of this case, this petition is dismissed as dismissed as not pressed, correct? जो उसका किए हैं
कर दीजिए
dismissed as not pressed. और आगे बताइए
5151 ऑफ
इसका
2020
क्या कहानी है?
इसमें भी इंजंक्शन अगेंस्ट डीसी पाया डीसी और स्टेट को और जियाडा के खिलाफ मांगे थे। ये भी रेस्पोंडेंट नंबर 1 to 5 and 7 to 9 इसको फाइल किए हैं इंजंक्शन के लिए कि उनको रोका जाए काम करने के। नाउ द स्टेट इज नॉट बिफोर योर लॉर्डशिप, तो उनके खिलाफ कोई ऑर्डर पास नहीं किया जा सकता है। देन इट हैज बिकम इनफ्रक्चुअस, इट कैन आल्सो बी डिस्पोज्ड ऑफ।
IA number 5151 of 2021 has been filed seeking injunction. This petition has been filed on behalf of respondent number 1 to 9. किसकी तरफ से फाइल हुआ?
ये रेस्पोंडेंट नंबर 1 to 5 and 7 to 9
1 to 5 and 7 to 9. Since nobody is appearing on behalf of respondent number 9 to on behalf of the state respondents to press this interlocutory application, accordingly this IA is also closed. आगे बताइए।
और फिर है
Is dismissed as not dismissed क्या closed कर देते हैं क्या करें?
क्लोज कर दिया जाए मानो
Close कर देते हैं, that is better. आगे बताइए।
देन 1949 ऑफ 2022
1949 इसका क्या कहानी है?
ये रेस्पोंडेंट नंबर अर्लियर रेस्पोंडेंट नंबर 23 थे, आफ्टर डिलीशन रेस्पोंडेंट नंबर 21 बन गए हैं। ये वैकेटिंग स्टेटस को ऑर्डर के लिए कहे थे जो 3/3/2022 का दिस ऑनरेबल कोर्ट के द्वारा पास किया गया।
तो उसको क्यों हम विकेट करें? Why should I vacate it?
It can be disposed of university क्योंकि इसके बाद फाइनल ऑर्डर ऑलरेडी पास हो चुका है, उसके बाद रिमांड बैक हो गया। These all these IAs are pending as prior to the passing of the final order by this honorable court.
Status को ऑर्डर रिस्टोर हो गया क्या?
नहीं हाँ वो जितने आईए थे ना, वो आईए को स्टेटस जितने आईए पेंडिंग थे उससे सारे पेंडिंग आईए को रिस्टोर कर दिया गया था बाय द ऑनरेबल सुप्रीम कोर्ट। दैट्स व्हाई ऑल दीस आई आर लिस्टेड।
May I pray one thing?
ये 23 की है।
बताइए।
On Monday, if your lordship takes it up,
कुछ
even
orders
otherwise I was going to mention it for because there was certain direction.
देखिए जितना इसका हो गया है ना वॉल्यूम, अब हम इसको झेल नहीं पाएंगे इतना वॉल्यूम।
अरे कुछ नहीं है ये
वो हम जान रहे हैं कुछ नहीं है, लेकिन ये इंटरलोक्यूटरी एप्लीकेशंस के कारण ये पेंडिंग है ना।
ठीक है, हम I'll take only 10 minutes if all the IAs would be disposed.
हो तो गया, अब तो हो ही गया, फिर क्या है? रिस्पॉन्ड नंबर आप किसकी तरफ से?
I'm for the original plaintiff who are original
रिस्पॉन्डेंट नंबर
contesting
1 to 9।
1 to 9.
तो बाकी सब में तो आपका नॉन अपीयरेंस कर दिया, अब इसमें क्या करेंगे? वो सब हम ड्रॉप कर दिए, हम क्लोज कर दिए सब। कुछ कहानी नहीं करना, बस फाइनल आप लोग अपना तैयारी करिए। सब क्या एडिशनल एविडेंस है और क्या है क्या नहीं बताइए। इस आईए का वेकेटिंग स्टे का क्या करें?
Vacating stay.
स्टेटस को ऑर्डर है, इसको नहीं लेट इट रिमेन, इसमें क्या करना है? ठीक है, आईए नंबर 1949 ऑफ 2022 in FA number 43 of 2012. This petition has been filed seeking vacation of order of status quo passed by this court. आप लोग तैयार हैं ना इसको फाइनल डिस्पोजल करने के लिए? The learned counsel for the parties have jointly submitted that they are otherwise ready to finally argue the matter. In view of the aforesaid circumstances, this court is not inclined to allow IA number 1949 of 2022. हो गया? और बताइए।
9191 your lordship.
वो सीरियली आ रहा है।
ठीक।
9191 है, इसमें रेस्पोंडेंट नंबर 1 to 9 फाइल किए हैं फॉर डिलीटिंग द नेम ऑफ 20 to 23। नाउ 20 21 ऑलरेडी डिलीट हो चुके हैं। नाउ 20 and 23 will defend this IA also.
Who are used for 20 and 23?
Why I have sought deletion that time. Now state your lordship background is necessary. Now I am the original plaintiff. I filed a suit against them. There is no dispute with regard to this because my claim was that I am claiming on the basis of auction sales which were conducted in the year 1930, 40, 50, all those court sales, I purchased the entire interest of the ex-landlord. This was the reason. So ex-landlord was Datta's and we are Paul's. So Paul's purchased the entire intermediary interest which included the suit property also. So this was the background of the case. Now when these Dattas, they transferred certain properties to them recently, then we filed a suit against them and that means other Dattas also. That means they are transferors also. We filed a suit. Suit was contested. Suit was decreed in the favor of Paul's, taking note of several facts, which also included that earlier round of proceedings when the lands were acquired, the compensation was paid to me in a reference case. Thorough proceedings were undertaken and then form were issued in our favor. All those were taken into account. And apart from this, there was also an order passed by the Deputy Commissioner who, pursuant to the order passed by the High Court, he had taken note of all the facts and their stand or our stand, and he excluded only certain plots from our M forms, and with regard to all those restored our Jamma Mandir NR. Detailed order, that order would clarify everything. Now, thereafter, when the suit was filed, suit was ultimately decreed in our favor. Then they challenged. They filed an appeal against that judgment and decree, obviously. During the pendency, therefore I say, when they filed an appeal, the state out of nowhere, it transfers 3 plots to Asarfi Hospital. This is the whole crux of major dispute between the parties.
Assuming that it has vested in the state.
Yes. It claims that it is Gair Majarwa and therefore it has vested with the state and therefore it transferred 3 plots.
So state authorities, why they have been deleted from being party?
Yes, that I'll come. Therefore, now, please refile an application. That means the original plaintiff, although we were the respondents, we filed an application for impleading the state, and because state had transferred these 10.92 acres, 3 plots in favor of Giarda, and the Giarda in turn transferred it to this Asarfi Hospital. So all these were ultimately the state, Giarda, and the Deputy Commissioner, they were impleaded as party from 20 to 22. They were impleaded as respondent at our instance. And the Honorable Court, it passed this in this proceeding itself. The Honorable Court took note of the fact that the suit, it is a part of the entire suit property itself, and the matter can be finally adjudicated. Therefore, the state was called upon, it was added, and then the proceedings continue. So, therefore, Asarfi Hospital, who is respondent number 23, they filed an application that because the state has transferred 10.92 acres in our favor, and they have already been impleaded as respondent number 20 to 22, so please implead us also. So their intervention application was also allowed because state was already impleaded as a party. So all these 3, that means 20 to 23, 4 parties, they were impleaded in during the appellate stage itself. Now this order was passed 4 or 5 years back. After 4 years, when the matter was being finally heard, the state filed an application when the matter was in the first round of proceeding, that means before remand. The state filed an application that please delete us because we did not get an opportunity to file our pleadings, written statement, and no section 81 notice was served, and all those grounds were taken. So therefore, state said that please delete our name because this judgment would not be binding on us. So that was rejected by the Honorable Court, by the orders which ultimately have again been revived by the Honorable Supreme Court. The earlier round, the court said that you have been given full opportunity, and because this is a part of the entire suit property, you are given full opportunity to place your case, and then after hearing and after giving opportunity, the final order was passed, which included the orders with regard to challenging the validity of the transfer made by state with regard to 10.92 acres in favor of Asarfi. So this was also
part of the earlier round of judgment which was passed by the Honorable Court, and the Honorable Court held that all these properties belong to the Pauls who are the original plaintiffs, and because the state has wrongfully transferred this to a Asarpi hospital, therefore this transfer is also bad. This was the finding.
The transfer
Now,
was during the pendency of the suit.
Pendency of appeal. When the
Pendency.
appeal was pending before this one. Therefore, the Honorable Court said that this was
Why was the need for an order of remand?
Yes, I'll come to that. Now, the Asarfi hospital as well as state of Jharkhand, they preferred SLP before the Honorable Supreme Court, and their stand was, particularly the stand of state of Jharkhand was that no section 80 notice was there, and we had never been given an opportunity to contest the suit before the trial court, and no written statement was there on record, and therefore our right was hampered, whatever may be, rightly, wrongly, they said this, and because no written statement was there on record, therefore that was the reason that ultimately we agreed for a remand. And now after remand, the state again pressed, because all the IAs were revived by the Honorable Supreme Court, the state again pressed their IA for deletion of their name, which has been allowed by this Honorable Court after remand by previous one.
So that has been that order has attained finality.
Yes, absolutely.
Okay, now
Absolutely.
state authorities are not a party.
State is not a party.
Asharfi Hospital is a party.
Is a party.
Who is
Therefore, I
respondent
say.
number 23.
Yes, therefore, I
So
say.
you are respondent number 23.
Earlier
respondent
23, now 21.
My contention,
Sorry?
Your
Earlier we had the 23
Asharfi Hospital is
Yes.
represented by him.
My-
Because he has also not filed any written statement.
No, therefore I say, my contention was, I had agreed when the remand was made, when the state, in second round I agreed that yes, I'll be filing a separate suit with regard to 10.92 acres against both state as well as Asarfi hospital. So please, I conceded to the prayer of the state, and therefore I filed this 9191, that state alone cannot be deleted as from the area of parties. If deletion has to be made, the entire, that means Asarfi hospital also has to go, because then I will be filing a suit. I have already, after this state was
9191 में order किए हैं क्या अभी तक?
नहीं, कोई
कोई ऑर्डर नहीं है।
I'm
इसीलिए
afraid
एक
that-
ऑर्डर, लास्ट ऑर्डर था हमारा कि हम आइए की, सॉरी 9191 में
because
This 9191
because-
has been filed so that
My contention-
Asharfi is also deleted.
yes, my
Such that
contention
this judgment may not bind them.
yes, therefore I say very clearly in this petition that because state has transferred the property
Have you
to
filed
them,
your suit or you have not filed your suit?
I have already issued a section 80 notice. I say that I will be filing. When I say that I will be filing a separate suit against them, how can they insist to be a party in this? They say that no, there will be a party in this, and then they also say that this judgment would not be binding. Either of the two they have to accept. Either I'll concede to this also, Your Lordship, very fairly, that Your Lordship, if they are parties, they must make a very clear statement that whatever ultimate judgment would come, they will not take this plea before the Honorable Supreme Court that no, we have not been
They are
given an
seeking a remand. They
They-
say that
they-
the matter should be
they
remanded.
they
And
take
then
two-
they should be given an opportunity to file the written statement
No.
and they want to contest. This is
Only
their stand.
because
It's a fact.
Your Lordship may see the order.
At the very opening
If-
session
we
of the before the
cannot-
honorable, because
we-
I prefer SLP.
We cannot supplement anything which is there not there. on
Lordship,
record. I'll read out the entire order. Your Lordship may see the order.
I prefer the SLP, and at the very beginning, the honorable Supreme Court.
You just tell us one thing.
Huh.
There are two people fighting regarding their right, title, interest, possession, etc. If there is a third person who has a claim through a third, altogether a different claim, because property has been transferred to you by the state, correct? Therefore, whether the state had the right to transfer or not will have no bearing so far as this judgment is concerned.
But why I am insisting so far the WS is concerned, Lord, that in execution case, the executing court has passed attachment order against us.
No. This is- I say
Then
very
because in the
clearly,
trial court house I moving.
Your Lordship,
You see,
Let me
if
say that.
I
the
see
executing court, just
10.92
one thing,
acres,
if
my
the-
I have no
Lordship,
right.
kindly
if
consider.
the executing court
Ah.
has passed an execution
And
order
made
against
party is also there.
Just a moment. You have a remedy under the law that you can say that this judgment is not binding on me. You see, you are inviting a judgment. You are in the interest of your client also. Think of it. You are intervening in a matter where you are not a party, and once you become a party, then every judgment passed by this court will be binding on you.
But what about the execution?
For the execution case is concerned, he
I
says
say
that
that very.
your property will not be subject matter of execution.
Absolutely.
Because he is going to file a separate suit.
When?
I have already issued section 18 notice
without encroaching my submission. In the court below, my friend goes there. I am also there in the court below, and he's telling that let this execution be against
No. Your Lordship
and so
may record my submission. Your Lordship may record my
ऐसा
submission.
सबमिशन से नहीं करेंगे, आप एफिडेविट
हम कर देंगे,
बस आप हो जाएगा आपका कहानी
and let us be freed from the execution proceedings.
Yes,
absolutely.
Certainly, because you are asserting a separate right altogether, correct?
But if the execution
अच्छा,
proceeding is
आपने
there,
वहाँ पे अपना ऑब्जेक्शन फाइल किया एग्जीक्यूशन में?
हाँ,
क्या हुआ उसका? ऑर्डर हो गया?
ऑर्डर
हो गया?
Order attachment was allowed, and when matter came up with your lordship, your lordship.
You have not challenged that order.
Yes, I challenge, and I was there.
Where is that? In which case you have challenged that order?
Here I have raised this point also, and in the
No. You see, if an executing court passes an order, then under such circumstances, if it is against, in the executing court, a person who is not a party of the decree, right? If the execution is going on against him, he has got a right to object to the execution by saying that I am not deriving any title from this decree or the parties to the decree, right? You are asserting an independent title, correct? So that particular petition has to be disposed of by the executing court.
But attachment has been passed now, and so I
I'll file an affidavit here.
Let the affidavit be filed. Let the affidavit be filed, because in the executing court he is pressing for attachment of the
If appropriate affidavit is filed that they will not execute so far as your property is concerned, and they have already undertaken to file a separate suit, then under such circumstances you should also be deleted as a party in this case.
That will come, but let the affidavit come that executing court is.
This is the problem.
Problem is in the law.
अगर आपने इसमें insist किया that you want to continue to be a party here.
No, Lordship, I am not insisting, but the question is that in the execution case.
कौन सा execution case है बताइए? Execution case का number बताइए. Execution case number?
I have not brought that because I thought that I would raise this by IA. I have not brought. Next date I will explain. Of course, let my friend file the affidavit.
I'll file it.
30 of 23. Excuse
30 or 23. Pending in the court of?
Pending civil judge senior division number 1.
Sorry?
Civil judge senior division number 1.
Civil judge
senior division
number 1 at?
Dhamma.
We are calling for the order sheet on this. And you file your necessary.
And my execution against 10.92 would not be maintainable after I file this.
10.92.
92. 3 plots are there.
10.92, which has been transferred by the state to Asharfi.
Yes.
Respondent number?
Giada and then to
Respondent number?
23 earlier, now respondent number 20.
Earlier, after the passing of the enforced orders, the counsel for the respondent number 1 to 9 has appeared. बाकी सब में तो आपको IAS से कोई दिक्कत नहीं है ना? Lot में नहीं IAS I have said as not present.
वो सब हो जाएगा.
नहीं ऐसा नहीं है.
नहीं वो नहीं. Seriously, your lordship may see that all the IAs, your lordship may allow me to place, I'll concede. I say that I'll concede. But major
क्या हम
this
इतना
was
आधा घंटे से क्या सुन रहे हैं? मतलब what is it?
अच्छा
मतलब what is it?
वो-
कौन सा आईए आप नॉट प्रेस करना चाहते हैं, बता दीजिए. कौन सा आईए का ऑर्डर हुआ है, बताइए तो. कौन सा आईए का ऑर्डर हुआ? I will record that you don't want to press it.
IA number 5043.
5043 not pressed.
Then
yes, 5043 I'm not pressing.
लिखिए 5043 not pressed. Respond number 1 to 9. आगे बताइए.
5055 का ऑर्डर हुआ था.
नहीं, 1534 again contempt. Under contempt of courts
हाँ.
act 1534 of
वो सब क्या
2018.
कंटेम्प्ट आप प्रेस करना चाह रहे हैं?
Because
नॉट प्रेस्ड कर दीजिए.
yes, yes,
ये
I
ना,
say
लिखिए,
that.
लिखिए. कौन सा आप बताइए, कौन सा आप नॉट प्रेस्ड करें?
हम बता. Then IA number 5055 of 2020 for early hearing, this also may be disposed of.
ठीक है.
IA number 4321 of 2020
एक second.
again filed by us.
4321 of 20
20
not pressed.
for violation of status
Not
quo
pressed.
order, again not pressed. Then 5151 of 2021 again under order
Not
39.
pressed.
Yes.
Okay. और बताइए.
My lord, 4321 is not there IA. I'm just informing the court. That is the IA of respondent number 16 to 18.
छोड़ दीजिए इसको.
No, but it has been written that I
नहीं,
filed for violation of the
16 to 18 की तरफ से कोई
वो
नहीं है.
स्टेटस को ऑर्डर का वायलेशन.
कितना आप लोग एकदम परेशान कर देते हैं कि जब मन होता है तब कोर्ट में घुसते हैं और कुछ भी बोलते हैं.
But I have, from the all the IAs I have made the.
ऐसा
has
है
filed-
Mr. Rahul.
Yes.
Some of the IAs I have said that you are not here and therefore I have dismissed as not pressed. अगर आपको कोई भी IA में लगेगा कि नहीं इसको आपको प्रेस करना है, you file a petition seeking recall of that. ठीक है?
Otherwise, अच्छा ठीक है.
कुछ भी नहीं है. इंजंक्शन क्या सुनना
नहीं नहीं,
है?
इंजंक्शन हम बोलेंगे भी नहीं है, हम बोलेंगे नहीं. Once your lordship is taking up the matter on merit, एकदम एक single line नहीं बोलेंगे. Only those IAs which ultimately would affect the merit, otherwise I'll not even say anything.
सौरभ हमको बताइए कौन सा IA में ऑर्डर किए हैं?
5043.
5043 किसका है ये?
Respondent number 129.
1 to 9 not pressed.
हाँ,
not pressed. बताइए आगे.
IA 5055.
5055
ये early hearing के
हाँ,
लिए
early hearing
not
not
pressed.
pressed.
आगे बताइए.
5710.
5710
ये against state file किए थे.
not pressed.
Against respondent number 20
हाँ,
DC
not
control.
pressed because
आगे बताइए.
IA 5151.
5151 not
ये
pressed.
prayer हुआ था against injunction.
Not pressed.
Not pressed.
4321 of 20 not pressed. ठीक है? Correct?
Yes, according to me, I am correct.
20 not pressed.
1949.
1949
ये respondent number 23 फाइल किए थे vacating the status quo order that my lord has.
हाँ, उसमें हम ऑर्डर कर चुके हैं. जो ऑर्डर रहेगा उसका. ठीक है? ये लीजिए. ये सारे और हैं. रेस्पोंडेंट नंबर 9 का अपीयरेंस रिकॉर्ड करके नॉट प्रेस्ड करवा देंगे. चलिए अब हम लोग का रेफरेंस का टाइम हो गया है. इसमें एक तो डेट हम देंगे, लेकिन भैया आप तैयार हो जाइए. आप
हाँ.
और जो भी आपका एफिडेविट बताए कितना दिन का बाद देंगे.
हम एक वीक में दे
एक
हम 4 दिन में दे.
नेक्स्ट फ्राइडे को. ठीक है?
ठीक.
अब आगे आप
Only-
कितना देख रहे हैं?
Only it may be taken up at any earlier point of time, 2:15 or.
नहीं ऐसा नहीं. 10:30 बजे आएगा, आप अलर्ट
हाँ,
रहिएगा.
ठीक
इतना
है.
मोटा रिकॉर्ड.
अरे उसके लिए नहीं, बिकॉज कोर्ट 4 बजे होता है इसी के लिए.
10:30 बजे होगा.
ठीक.